Last Friday at 2 p.m. I tried to mention one matter in view of the urgency. She asked me to come today. What happened, my lord? I'm the West Bengal State Electricity Distribution Company. Now, in a suit, my lord, I have filed an application for amendment of the written statement that has been turned down. I mentioned previously before Lordship Court, Lordship Director matter to appear in the monthly list that is appearing. I wrote a letter. Now, my lord, the court below rejected the same, which cost 5,000, and my lord fixed next day. My lord, on 24th of July, I have brought the order sheet for evidence, and in default, my lord, my evidence will be closed, my lord. If your lordship kindly any day, my lord, subject to convenience, my lord.
Hand over the slip mentioning the urgency.
May I have kind leave to mention, I had mentioned this on 10th because they filed first we moved the matter, the other side came and said, give me a copy. The matter was kept thereafter. Then immediately next day they went and filed a contempt of that order, which is assigned for your lordship.
What is the item number?
57. Lordship had fixed it either today at 2 or 3. It's not appearing as such. It could be taken at any time.
Mark করা নেই? 57.
57, yes.
57 come at 2 p.m. Notify the other side.
Yes.
Just whether kindly sees your lordship's order on 8/7. I have annexed here in the order. Because of the first time, there is no caveat on behalf of the other side, but misleading the court, they have mentioned that caveat is pending. But one caveat was pending, that was expired. Lifetime of the caveat was expired. Unfortunately, the other side mentioned the matter that caveat was pending. My lord was pleased to give direction to serve the copy, but the inadvertently, perhaps the date has not been fixed even. So kindly matter mentioned, kindly just appearing in the list under the caption to be mentioned.
To be mentioned,
Yes.
to be mentioned tomorrow.
My lord, may I seek my lord's kind indulgence?
Yes.
My lord, last Friday, a matter was dismissed for default due to my absence, my lord. The order is not yet in the server, my lord. In the second half, it happened. I was on my legs in other court, that's why I could not come. If my lord pleases
I
to
file an application because it has been
order is not yet in the server, my lord.
online now,
If my lord
not
pleases.
like the earlier.
Because it is a matter of embarrassment, my lord can appreciate.
Follow that, but cannot be done. Now we are online, live streaming, everything. Yes.
Last Friday, my lord has passed an order. My lord, Mr. Dotto is appearing, my lord, on the other side. My lord has directed them to deposit certain amount, my lord, before the learned judge commercial court, but no date has been specified, my lord. But kindly seize the order. My lord, kindly seize the order.
I have not. I have only modified that part. I have only said instead of the receiver, that will be done.
But kindly fix us a date, my lord.
I have only, madam, I have only modified to that extent.
They'll take advantage of it, my lord, and will not deposit.
Apprise the learned judge. I have only modified to that extent. Instead of the receiver, I have not modified anything.
My lord, may I permit a mentioning for upgradation, my lord? Tomorrow fixed for court below, my lord.
Please come on Wednesday. Yes.
Tomorrow is the date for police report on delivery of possession. The item number is 1272.
Why did you not mention last Wednesday? Please come on Wednesday. Yes, call the
May I have my lord's kind leave, my lord, to mention, my lord, extremely urgent matter, my lord. Kindly bear with me, lord. The matter was appearing on the 16th of June, my lord, as a 2 p.m. matter. I could not appear, my lord, due to my personal difficulty, and therefore the matter, my lord, lost its precedence. My lord was pleased to, my lord, on my mentioning the next day, my lord was pleased to say that if I come, my lord, I should mention sometime in the month of July, so that my lord can give me some precedence. Here, my lord has entertained the revisional application arising out of vacating of an identity order of injunction.
Mention on Wednesday for upgradation. Yes.
I also upgradation.
Please come on Wednesday.
Obliged.
Wednesday, yes, call the list.
Item number 1.
I am for the opposite party.
I am for the petitioner, my lord. It has come at my instance, my lord.
Yes.
But the parties have come to, it's a matrimonial proceeding. Parties have come to a settlement, my lord. Does not intend to proceed, my lord. I've got the written instructions of the petitioner, my lord.
The learned advocate appearing for the petitioner submits
this came up on my instance. I mentioned it for upgradation. Number, if your lordship kindly look, it's a matrimonial proceedings, group 8 proceedings. Now, the petitioner is the wife. Now, the husband filed an application under section 7
Why
of the.
to be mentioned?
Now, I mentioned the matter, it came under the heading to be mentioned. I mentioned the matter with proper urgency, mentioning the proper urgency.
The application for interim visitation right was rejected.
No, my lord. So what happened, my lord, the Act 8 application was finally disposed of. You will also kindly come to page 80. The order of the learned trial.
That is your mentioning slip. You have written that.
Yes, thereafter it is mentioned.
Where the order learned trial judge pleased to reject the petitioner's application for interim visitation right.
Yes. That is
You are saying no.
No. I'm saying that that's the fact of the case.
That is,
Husband-
I've seen the mentioning slip. That is why I've kept it as to be mentioned. On going through this.
That is true, my lord. I'm not some. What happened that my Act 8 case filed by the husband
Yes.
was allowed on mutual consent. The child is a special child. He needs the medical treatment. Since the wife is not in position to lordship arrange the cost for medical treatment, the husband was given custody of the child. If you also kindly come to page.
What do you want now?
Now, the order was disposed of, directing the husband to giving the husband the custody, and wife was permitted to visit the child one in every month.
Yes.
No visitation was given since after disposal. Now, I filed.
What can be done here, Mr. Ghosh?
I have filed an application for execution of that order.
Yes, execution application has also been dismissed.
Dismissed on the ground, if you also kindly
non-compliance of the court's order.
But kindly see that before that order, just before that thing, the matter was running before the special judge, come ADJ. It was subsequently on 19th August 2024. It was assigned to the.
You are not present, Mr. Ghosh.
My advocate was present, but since a family court, my advocate was not given access to the court. He was not allowed to file.
Cannot be done. Family court.
Kindly consider the situation of the wife. She is not able to visit the child for the last 2 years. March 2023, order was passed, giving custody to the husband.
Where is that order?
Page 18.
18.
Now, relevant paragraph is relevant order in portion is page 22. Page 23, kindly see. Let the custody of child Surya Banerjee be given to his father, that is the petitioner, with immediate effect for betterment of the child who is patient of cerebral palsy. The OP is directed to hand over the child Surya Banerjee to the petitioner today itself in court. The petitioner is directed to make arrangement for proper medical treatment of the child and for proper education of the child to the best of his ability. The petitioner is further directed to bring the child once in a month to the Seresta of his learned advocate for his meeting with the OP from 10 a.m. to 5 a.m., preferably in the first week of the month, with 7 days prior notice over phone to the OP. The instant application is disposed of. But thereafter, execution has been filed. In the execution case, repeated occasion direction was given upon the husband to produce the child. So he never produced. If you also kindly see the orders, I have annexed the entire order sheet of the execution case.
The execution case, if you don't appear, what the court can do?
But if you also kindly look into the order number 11, 19th September 2023. The learned advocate for the petitioner submitted the petitioner has not been able to meet her child for over 2 years, even though
either you did not appear or you paid for time on all occasions.
But what happened, my lord, after opening of the family court in Asansol, there was an ongoing strike. The first date on 19th August 2024, there was a strike. And we could not appear. On the next day, my learned advocate appeared, but he was not allowed to appear.
Strike of the learned lawyers.
It's
family court, you have to appear personally.
Kindly consider the situation, but you have not, I don't even know that the family court will not allow any representation by a legal practitioner. But only privilege child we may kindly allow me to.
By the order impugned, the
my lord.
Yes.
On Friday, my lord, this matter was appeared, my lord. There was a discrepancy regarding the 26th June order. There was no name of the advocate for the opposite party number one. Thereafter,
You appeared.
I appeared for the petitioner.
Yes.
For the opposite. Now the party has appeared on the last occasion. Friday also he appeared. My lord directed.
Name is not there.
Yes, my lord directed me to serve a copy of the petition to him. I have served
It
him.
was not there. The Wakalatnama was filed on 26th,
Oh, so
23rd of June.
So it is appearing correction.
Stated on the last day, my lord, that I have not filed the Wakalatnama, therefore he had not given the petition. However, my lord, later on he did give the petition.
On the same date I had given, my lord.
No, not on the same date. So I don't make.
On Friday itself, I
It
have.
has appeared for correction. What is the correction?
No correction is there. That has wrongly appeared as correction. But I have mentioned the
Giving the slippers for correction.
Yes.
But I have not written the correction. Correction was written by the
You
court.
said it is for correction.
No, my lord, kindly see, my lord, on 9th.
Otherwise, why it will be appearing under to be mentioned? Why did you mention for?
Yes,
Where is
my
the
lord, on
mention?
9th June, I had mentioned the matter as because my lord had directed the stay of the OA, my lord had directed the continuation of the OA proceeding.
Yes.
Despite that, and
Yes.
it was made by the prayer of the learned advocate for the opposite party. I could not look at the opposite party because the name was
How
not
is
there.
here?
But I've given him the copy. But the matter is on 17th of July. But only one thing, I have challenged the genuinity of the signature.
Consider.
My can you see?
You have mentioned for correction. Now you are saying
I have not mentioned for correction. I have not mentioned.
this matter was directed. Out of list from the heading of to be mentioned.
But on Friday,
I could not also locate what was as to what the correction was
there
in
was
the
no
order.
correction, my lord. I have not written correction, my lord.
Then it
Kindly
was
consider the
mentioned
code
in
of-
that.
All right, I have
time
recorded your submission that there is no correction.
Very well, my lord. Grateful.
There is no necessity for.
But on 17th of July, the matter will become
You
infectious.
have not said that you have not indicated in the mentioning slip. That was the ground for mentioning. Yes, call the next matter.
Item number 4, 4 was here. Item number 6.
6. Yes.
My lord, this is for extension of interim order, my lord.
Yes.
Order has been passed by my lord Justice Shampar Sarkar on 3rd of January 2024.
Yes.
My lord, if your lordship kindly peruse the order passed by your lordship, my lord.
Interim order was still.
My lord, that is still, my lord, thereafter, my lord, application for extension of interim order filed, my lord. And in the meantime, my lord, petitioner died, my lord.
Party expired, your lordship.
My lord, application for
substitution
substitution has
is
been
pending.
filed, my lord, that was allowed.
That was allowed.
Yes, my lord. If your lordship kindly come to order dated 13th of.
What is the impugned order?
My lord, impugned order, my lord, is rejecting my application under section 47 of the Code of Civil Procedure.
Section 47.
Yes, my lord.
Yes, what is this matter about? Yes, proceed. Let me take up the main matter. What is there in the main
Well, the
matter?
main matter, your lordship kindly give me 1 or 2 days time because I have some judgment and law point on this point, my lord. Your lordship kindly next week, any day, my lord, or in this week, my lord. So far as the main matter is concerned, my lord, there are such some important point, my lord. Not like
What is the
usual,
important point?
not like usual point. My lord, no finding of the learned court with regard to the.
All right, when do you want?
My lord,
When do you want? I will keep it on that date. When do you want?
next week কবে দেবে বলো? My lord, can I make it in the next week? Not 21st July, my lord.
Not 21st of July. Why?
My lord, all of us some problem, my lord.
When do you want? Give me a date.
27th.
27th.
No, অত দেরি হবে না। 22nd, my lord.
22nd. When this matter is taken up for hearing, Opposite party is represented by the learned advocate. That's it.
Obliged.
Grateful, my lord.
Item number 7.
7, my lord, I am for the petition.
Yes.
I am for the plaintiff opposite party.
My lord, the order impugned is, my lord, allowing an applications under order 39 rule 7.
I'm extending the
Interim order expired long back. If you
My lord, in December 2000 up to January,
If
my
you
lord,
are-
the
I will
interim
remember
order.
this, Mr.
No, no, no.
Mukherjee.
My lord, the application has
Long it cannot be extended. I will remember this.
I'm not on that. No, no, I'm withdrawing myself.
Sometimes appear for petitioners also.
and my lord, another
If your
application.
lordship see once the impugn order. If your lordship see once the impugn order.
Yes. What is the suit for?
This
Order
suit-
39 rule 7. What is
Hello.
the suit for?
The suit for declaration that the disputed passage is a common passage. We have claimed that this is our property, this is all extent, this is our property. Therefore, this is not a passage. This for, my lord, the question of passage. After that, my lord,
Where is the appearance of local inspection?
kindly turn to, my lord, page
39.
39. Yes. My lord, kindly turn to page 41, the schedule. The suit common passage with reference to sketch map annexed in the and also that holding number 15 Ramon Mukherjee Lane. To note whether the boundary line along with the eastern boundary line of holding number 14. To further note whether there is any 4 feet common passage along with eastern boundary line of holding number. But so far as the passage is concerned, this is a part and parcel of our property.
Yes.
We have claimed that this is, we
So,
filed
so
it-
that how can it be proved by way of local inspection? Whether it's part and
Is my
parcel of
question, whether that can be, my lord, by way of order 39 rule 7, my lord, this cannot be ascertained. Whether this is part and parcel.
Yes, Mr. Mukherjee.
Kindly see, but I am not pressing all the mallet schedule, mallet. I am not pressing all the schedule. Now, mallet, admittedly there is a boundary dispute also. But kindly
So
try,
boundary dispute, whether by local inspection it can be decided.
but if your lordship see once mallet two. But kindly turn to once mallet.
From these points which you have sought for,
But,
can the boundary dispute be decided, Mr. Mukherjee?
but whether point number 2 mallet, kindly delete mallet. To know, point number 3 mallet, kindly see and kindly consider mallet.
Or that, Mr. Mukherjee, your case is that whether it's a part and parcel of a property
No,
or not.
No, kindly see the written.
According to you, it's not a part and parcel of the property.
Yes, yes.
According to him, it's part and parcel of the property. So that's the dispute, whether this passage is a part and parcel of the suit property or not. Can it be decided by local inspection? Please satisfy the author.
Kindly turn to once mallet. The what is the dispute? If you lordship see once mallet, the page mallet in the
And so far as
starts from.
there is a permanent injunction also, so far as this passage is concerned.
Kindly
second
see the
page-
plaint case mallet. Plaint starts from page 12. Kindly turn to once mallet. Page 24 and 25. 24 to 26 mallet.
Plaint ends at page 22.
Huh?
Plaint ends sketch map. Sketch map is at page 24. Yes.
Paragraph 24 to 26 mallet. Page 19,
Paragraph 24.
page 19 mallet.
Page 19. Yes.
That the plaintiff also have been using the suit common passage more fully describing the schedule hereunder and depreciated as well as delanted the plan annexed herewith by green border line for the purpose of egress and ingress to and from their respective holding since the time of their predecessor interest or succession interest. That the holding number 15 Ramon Mukherjee Lane, Shibpur, Howrah is situated in the adjoining western side of holding number 14/2 Ramon Mukherjee Lane, as well as the suit common passage being demarcated by 10 feet wide boundary wall along with eastern boundary line aforesaid holding number 15 Ramon Mukherjee Lane. The trouble arose for the first time in the middle part of 2004 when the defendants claiming themselves to be the owner of the aforesaid holding number 15/15/2 Ramon Mukherjee Lane created disturbance in the peaceful enjoyment of suit common.
So what is 15/2? What is 15/2?
15/2, if you, because what they have purchased, they claims that they are the owner of 15 and 15/2 Rammon Mukherjee Lane.
Yes.
Now they are,
And you are the owner of 14.
14.
yes. Now kindly see their written statement. A written statement, your lordship will kindly take my lord page,
So you are the owner of 14/2.
but kindly see the schedule. And the prayer, my lord, page 21, for a decree for declaration that the suit common passage more fully described in the schedule herein below is the passage of the plaintiff only for the purpose of their egress and ingress to and from their respective holding number.
Cannot be proved by local inspection.
Now,
Can it be proved by local inspection?
in the written
Whether, so your case is that it's the passage for ingress and egress to that. So you must be having some documents to prove your right of ingress and egress to that. So this, for this local inspection is not necessary.
kindly see page 29 in the written statement.
29, yes.
Paragraph 17, my lord.
Yes.
But if your lordship kindly read, my lord, from 8 line from top, it is denied. 1, 2, 3, 4, 5.
It is denied, yes.
Denied that the holding number 15 Rammon Mukherjee Lane, Shibpur, Howrah, is situated at the adjoining western side of 14/2 Rammon Mukherjee Lane, as well as falsely alleged suit common passage, or that there was or is only 10 feet height boundary wall along with the eastern boundary line of holding number 15 Rammon Mukherjee Lane as falsely alleged or at all. The allegation made in the plaint are nothing but a cock and bull
Where
story.
is your deed?
But deed, my lord, at the present moment I don't have with me.
That will show.
But what happened, then, my lord?
Mukherjee, can this dispute be proved by the
But
points?
some of the
So to draw a sketch map, so your allegation is not of encroachment and other things.
Yes, yes, encroachment is there, my lord. If you lordship see once,
Show me your case of encroachment.
but kindly give me one.
So if it is encroachment,
Local
no
inspection.
mandatory injunction, no recovery of possession. If you say there is a case of encroachment, the suit is barred.
May I just see once? But kindly see page 30.
30.
30.
No, that is a different thing. Where is your case of encroachment?
No, my case is not
So-
case of encroachment. And local inspection, what is the point? Kindly see
Yes,
one.
yes. Kindly come to the points at page 41.
To go, but today, if your lordship reject this, my lord, I cannot approach under order 26 rule 9 also.
Mr. Mukherjee,
It
where is
can
the
be-
case of order 26 rule 9?
But local inspection, why it is necessary?
Local investigation for what?
Local inspection, my lord, may I just show your lordship, but the case made out by the defendant in the written statement. And your lordship has already gone through, my lord, page 29, paragraph 17. Now, my lord, if your lordship kindly see page 30.
All right. So I will consider this. Let the interim order. What was the interim order?
The interim order was stay.
You have filed an application. Can 2.
Can 2 is, my lord, for expanding, yes, my lord, for extension.
Extension is can 2. Can 2, this is an application.
for extension of interim order, application filed within time, previous occasion, the notice extended the interim order.
Why did you not mention before the expiry? Why did you not mention before the expiry? You have served the application,
Lordship, this is
received.
deliver.
Every service filed in court today is taken on record.
Extension of interim order expired on 30th of June 2025.
Yes.
Copy sharp not. Affidavit submission has not been happened within a half hour. I am submitting.
Then come tomorrow. Not today. Yes, next.
Then I am for the opposite party.
The matter can be disposed of.
Can be disposed of.
Today itself, I have got a very innocuous order, prayer before your lordship.
Lordship, kindly.
You are for the petitioner.
I am for the opposite.
Yes.
Lordship, this is an application challenging the order of the London ESI court. As your lordship knows that under 45A, a determination is being made by the ESI authority. Against that, an appellate provision is there under section 45AA. And thereafter, 75(1)(g), I can come before the learned court for determination of the amount and injunction and also waiver under section 75(2)(b). This is the second round of litigation against my client, lordship. My client is a car dealer. He takes car from different manufacturers and used to sell it out. Against me, 3 crores.
No, 13 crores.
No, I'm coming. I'm coming.
One figure has been mixed on the left, left-hand side. Yes.
For filing appeal, I am required to deposit 3 crores and odd. My learned senior friend is correct. The determination was 13 crore or something like that. ঠিক আছে স্যার আমি তো ঠিকই বলেছেন আপনি
Yes.
So what happened?
So a big company.
No, I am a dealer.
Default, my lord, is from September 2018.
Sir, আমি মেরিটে যাচ্ছি না স্যার. Just your lordship kindly take the trouble to consider my appeal has been dismissed, page 34. As per the Honorable High Court's order, if your lordship kindly take the trouble to 25, this is the first round of litigation. My client,
34.
Page 25, your lordship kindly take the trouble first.
Yes.
This is the first round of litigation. Page 26, the Honorable Court was kind enough to allow me, page 26, last para. The aforesaid
alternative remedy of appeal.
Yes, yes, 45. Then we filed it, but at that point of time, I was short of money, so I cannot deposit 3 crores an amount.
Pre-deposit amount.
Yes. And lordship, page 34, my appeal has been dismissed on that ground. Only no merit, nothing else. I have challenged the matter before the learned ESI court under section 75(1)(g), and I have paid for an waiver of pre-deposit under section 75(2)(b). 50% deposit is there. I paid for waiver and the injunction so that my bank attachment and all these things shall not be attached. Lordship, kindly take the trouble. Only 2 lines I will show from the impugned order.
Yes.
Lordship, last annexed, it will be last annexure will be lordship the internal page 2 of the order, just 2 lines.
Yes.
Para 3, last 2 lines. Lordship has a lordship got it.
Yes.
Page 2, internal page 2, last 3 lines. Therefore, the visit report in question has got no legal effect, and on the basis of such report, also the order under section 45A is not legal and valid. The learned court has already determined that 45A order, the initial order is bad because the report based on which it has been done is incorrect. Now, Lordship, kindly take the trouble. Why I am facing problem, Lordship, kindly take the trouble. My prayer was, Lordship, kindly, my prayer before the learned court was, kindly remand the matter to the ESI authority or to the appellate authority. Already the learned court has held that 45A order is bad. My prayer for remand has been rejected, Lordship. Lordship, my respectful submission is, subject to Lordship kind approval, kindly remand the matter.
Yes,
So
Mr.
that
Muthu,
that
what do you
can be-
say?
Now, your
Because,
lordship,
by this order,
yes,
it has been the 45A
yes,
Initial
which
order,
was against him.
13 crores.
That has been the court is of the view that that is not legal and
now
valid.
your lordship kindly come to, kindly hear me, my lord, kindly come to page 23, my lord. Page 23.
No, but only one thing, Mr. Dey,
Lordship.
please show me the statute with regard to waiver. Mr. Dey, if waiver is not granted, can that be decided on merit?
Yes.
Because what you wanted, you will be getting in a roundabout way by saying that no, I am not required to pay pre-deposit, and your effect, the ultimate object was to get the parent order set aside. Can you do that
Lordship,
without waiver?
but Lordship, may I submit only one thing?
You put I will direct remand.
Lordship,
Cannot be a roundabout way, Mr. Dey.
Lordship, kindly consider. I have my
What is
client
the provision for
75 to B.
first is 45A?
45 is the
45A.
first
45A.
first flag is 45A. Lordship, kindly take the trouble. 45A.
No, 45AA.
AA, Lordship. Thereafter.
45A is the appeal provision.
Yes.
Thereafter, the second page.
45AA is the
45A, Lordship, I have flagged with yellow flag. I think thereafter the next provision is 45AA. I have to pre-deposit 25%.
Yes.
That is
So
there.
So you did not do that.
Yes.
I could not, Lordship.
Did not amounts to the same thing.
Lordship,
So-
may I submit subject? May I submit subject to Lordship kind approval? Lordship, if your Lordship so wishes, kindly remand it back to the appellate authority. I am ready to deposit the money of 25%.
That can be done.
That can be
Sir,
done. Let it be heard out. I don't know.
Mr. Moitro,
Yes.
the appeal was not hard on merits.
Yes, Lordship.
So if the appeal was not hard on merits, but the he did not deposit, could not, he says could not, he will be saying did not. So if he's provided he deposits that amount, I will direct remand.
Yes.
Your
So
lordship,
soon, Mr. Dey, please deposit that amount
now,
and then I will remand
now,
it.
your lordship kindly see, after that, after
4 weeks, Lordship.
45A, the
Amount
order,
is huge. 4 weeks,
Lordship,
Lordship.
kindly
Kindly.
see,
4 weeks.
In this remand will be after 4 weeks.
they went to
Not
High
now.
Court.
No, I have to deposit with the authority, Lordship.
Yes,
I have to. Oh, Lordship, your Lordship wants to make the matter pending here.
yes.
I will deposit there. Lordship, kindly pass the order. I will
So, Moitro,
deposit
what
there.
do you say?
Kindly come
If he
to,
deposits, Mr. Moitro, the appeal was not decided on merits.
yes.
He has filed an appeal.
Against that, they went to the EI court.
He went to the ESI court,
The court
but,
also, they
but the
did not,
fact remains, the appeal was not decided on merits.
yes,
Because he did not deposit the amount, pre-deposit.
yes.
Let him deposit, I will be directing the appellate authority to decide that on merits.
Yes.
Provided is dispute. What is your objection to that?
As your lordship pleases.
স্যার এটাতে কোনো অসুবিধা নেই তো ইএসআই টাকা পাবে স্যার কোনো অসুবিধা নেই
No, no, let them deposit the entire.
Yes, I will.
enter, what is the percentage which you are required to?
25%, 45 AA, Lordship.
25%.
Yes, 25% is 3
13
crores.
crores, 13 crores,
No, no.
25%.
3 crores and odd. That will be.
Why 3
So
crores?
I am not saying anything, I will be saying that 25%.
Yes.
Whatever is 25%.
25% of the demand.
That 45
Your
double.
lordship would kindly see, therefore, you kindly.
Yes, yes, 25% of the contribution so ordered.
Yes.
Yes, 13 crores and all.
13
Yes.
crores.
13 crores and all.
Let them deposit the money.
No. Sir, 45A. AA I am coming.
45 AA.
45 AA has not been decided.
Yes.
They went up in appeal. Your lordship kindly consider. Therefore,
Yes.
until their lordships are pleased to determine 45 AA appeal, then 45A remains.
Yes, yes, 45A remains.
Now kindly see what is the 45A order. Kindly come to page 24. Kindly come to page 24.
The last paragraph.
Last paragraph. 13 crores, 20 lakhs, 84,404.
984.
Page 24.
Page 24 of their
Revisional application.
Yes,
Page
revisional
24.
application. No, where is the, he may prefer an appeal to the such and such within 60 days, deposited 25%. Where is the quantification made? Oh, top, yes.
Top is the
It is
quantification.
13 crores.
13 crores. That's right, Lord.
Yes, of the contribution so ordered on that.
Yes,
That
I am saying,
Yes.
provided he deposits 25% of that,
yes,
that appeal will be restored.
yes,
Yes, sir.
yes,
Lord,
Should be-
kindly.
So I'm disposing of this.
Yes, sir.
The revisional application may be disposed of.
Revision application, what is the appeal? ESI court is appeal.
ESA code is the
Verification.
application, is a case. Is a case.
I'm disposing of everything.
Yes, yes, everything.
Provided he deposits that amount, then the appeal will be.
Failing which,
I will
Failing
leave
which
the-
the order shall,
yes,
this order shall stand recalled and that.
Failing which I will in the jail.
Kindly-
Failing which I will be in the jail.
No, no.
Nothing else.
failing which,
This
the
application,
revisional application will
can আছে, Kentucky. What is the can for?
And for extension for interim order.
একদম
Everything.
শেষে করে দাও। This application Order
Yes,
is
yes,
trans-
the honorable court's order, we have filed the appeal. It has stated that 92 days, the 60 days, beyond 60 days, we have filed. That
it
is,
it was time barred. আচ্ছা
Lordship kindly.
ওই যেখানে বলেছি না যেখানে যদি ডিপোজিটটা to the issue
I'm declaring.
Item number 11.
My lord, I am appearing on behalf of the petitioner.
yes
My lord, the petitioner plaintiff have instituted a suit against the eviction of tenancy in respect of their civil property against the opposite party defendant. Subsequently, opposite party have filed an application under 151 of the Code of Civil Procedure for repairing of his shop room.
opposite party file
Opposite party defendant. Subsequently, plaintiff petition have also filed an order 39 Rule 7 application before the learned trial court.
what is the order impugned?
My lord,
Don't tell so many facts. What is the order impugned?
the defendant opposite party have violated the order of the trial court and extended the repairing work beyond the jurisdiction, his jurisdiction. Therefore, we have filed a 151 application for willful violation or order of the
151 or order 39 rule 2A.
Therefore, there is no order of injunction, my lord. There is no order of injunction. Therefore,
there is no order of injunction.
The landlord tenancy dispute, there is no order of injunction. Order 39 Rule 1 2 application has not been filed. Therefore, we have filed an application under 151 for violation of the willful violation of the order of the trial court, and the said order has been set aside, rejected by the trial court. By
What do you want? Repairing has been concluded.
yes, repairing has been completed. Kindly see the.
So you want eviction. Why are you delaying on this? What is the stage of the eviction suit? Why are you going to those repairing violation? Your main suit will get delayed.
My lord, I have also prayed before your lordship for expeditious disposal, my lord. I have also prayed before your lordship.
Doing that. Otherwise, if this is done, then that will be delayed. It's your choice.
Kindly direct direct the opposite party. My lord, I kindly consider my application, my lord.
All right. Yes. Where is your application under section 151?
My lord, page 45. My lord. Paragraph, my lord.
40?
Page 45.
Yes. Where is the order dated 14th of September 2023?
My lord, page 44.
44?
Yes, my lord.
All the prayers are under order 39 rule 2A. These are the reliefs which is usually granted under order 39 rule 2A.
Yes,
So in a roundabout way, you have prayed for those reliefs. How can it be done, sir?
Order 13 Rule 1 2 application is not even filed, my lord.
We appreciate that, but the prayers are relief sought for is under order 39 rule 2A. What did the trial judge say? Rightly. By the order impugned.
Allow the expeditious disposal application.
By the order impugned,
Adjournment, my
You
lord.
cannot say the stage.
My lord, kindly allow, my lord. Without granting any adjournment, my lord, kindly. My lord, I took instruction, my lord. Kindly,
Yes, yes.
without granting me any adjournment, my lord.
Yes, yes.
Item
Mr.
number
Chatterjee.
12, my lord, I'm led by Mr. Anindya Chatterjee in this matter. My lord, he could not come due to his father's yearly rituals, my lord.
Yes, what is this matter? Yes.
Matter
start.
pertains to, my lord, order is under challenge of the National Tribunal Consumer Forum, my lord, where, my lord, the petitioners has been, my lord, charged with, my lord, medical negligence. Now, my lord, that order is under challenge. Now, my lord,
National Commission means it's an appellate order before the
Appellate.
National Commission.
yes.
Buddha Forums, if Buddha Forums is against you, Mr. Chatterjee.
No, my lord, I will
What's the
show.
violation?
No, I will show, my lord. The National Commission, my lord, has gone, my lord, discarding the views of the, my lord, State Commission, my lord, in holding that, my lord, there was any negligence, rather has made out a third case, which is not the case of the complainant event.
It is to be heard.
It is to be heard, no doubt. Now, my lord, and my lord, the West Bengal Medical Council, from whom, my lord, opinion was sought for at the behest of the complainant, the West Bengal Medical Council has categorically stated that there is no medical negligence. My lord, despite that, the National Commission made out a third case, my lord, which is neither the case of the petitioner nor of the complainant. Now, my lord, and my lord, charged the.
Before the West Bengal Medical Council, another case was pending.
No, they themselves referred. Initially, they say, my lord, an opinion of an expert is required. My lord, a doctor of the field, my lord, was called on, my lord, whose evidence was taken. He said that there is no medical negligence. He was cross-examined.
Yes, so
Now,
it has to be heard.
it has to be heard. It has to be heard. There is no doubt. My lord, in the meantime, my lord, let there be a stay of the order, because there is a
what?
My lord, there is a penalty, my lord, imposed upon the opposition.
Secure the amount. It's a money decree, Mr. Chatterjee.
My lord, I know. But my lord, if I
the amount. Mr. Chatterjee, you have to secure the amount. Money degree, secure the amount. Nothing will happen. You are not paying to them.
No, I'm not paying to them.
Secure the amount.
My lord, if I can show prima facie that absolutely, my lord, there is no medical
money degree, you have to secure.
My lord, kindly visualize those lines of decisions where, my lord, it has been held, if prima facie the tribunals are holding, all the expert bodies are coming to finding that there is no medical negligence, my lord, then
They can be granted unconditionally. Show me that decision.
May I come back on those? Because this prima facie
Strategy-
absolutely perverse. My lord,
I follow your submission, but the as a condition for grant of stay, the court can direct. You are not paying to them.
yes.
It will be lying in a deposit.
But if I may
It will
suggest,
fetch also interest. You will be getting back the amount, provided you succeed.
if I may,
Unconditional stay, no.
if I may suggest, my lord, this matter would not take much long time. My lord, if this can be heard tomorrow, my lord, it will take 5 minutes of time, only 3 paragraphs of
According to you, 5 minutes of time. Court takes a more time to understand, Mr. Chatterjee. Court is not as fast as you are. That's the difficulty.
Now, my lord, may I come back tomorrow with the instruction how to secure? Because security can be in the monetary form by FD or, my lord, anything else, my lord, which amounts to, caters to that amount. Lord, may I come back tomorrow with that instruction? Tomorrow with that instruction.
Comply, not comply, there will be no stay.
No,
It's
my lord,
your choice.
no, we want to comply because it's an absolutely perverse case. My lord, in the meantime, my lord, to secure the
Yes,
amount.
Chaturvedi, what do you say?
Could it be taken up day after tomorrow?
Why?
My learned friend Lord wants to come back tomorrow. I say instead of tomorrow, day after tomorrow. And so far as what my learned friend says, possibly, my Lord, he is not posted with the facts correctly. There is an expert committee appointed.
I'll show.
Yes.
Yes, RG court.
Yes.
An expert committee of experts, medical experts, was appointed at our instance. We filed an application before the State Commission. It says unequivocally that there is every possibility of an error in the treatment given to the deceased. Blood.
What happened?
Died.
No, well, he died. His
died.
patient.
Not the ultrasound in case of a delivery, the ultrasonography is saying that the placenta is posteriorly placed, and the operation doc ticket, it says that the operation has been done anteriorly placed. That resulted in, my lord, toxemia. What, my lord, in ordinary sense we know septicemia, and she died.
No,
And she died on 5th. Please, sir.
Very well, sir.
She was admitted on the 14th March. 15th March, the operation was done. 15th March, on the operation blood table, She suffered severe heart attack and she died. But the report says that she died on the 19th. For 4 days, they put her in brain dead patient blood on ventilation. I come up with all this, and this has been conquered in first appeal. In 227, my lord knows, my lord would not reappreciate the evidence. My lord would only look into it whether there was at all any evidence which resulted in the order impugned. That is a recent judgment, my lord, I shall place before my lord.
Absolutely, my lord.
About 2001.
Absolutely, my lord. This RGCO's finding, my lord, they themselves were not satisfied because my learned friend seniorly utters the word possibility. Therefore, my lord, medical council was referred at their behest. Then, my lord, the medical council, there is no negligence.
Heard Mr. Chatterjee, learned safely. List this matter under the heading motion. Yes, next week.
My lord, any day, my lord. Today, because Mr. Chatterjee is due to that reason, my lord.
The next week. Yes, call the next matter.
Next week, Tuesday. Monday is 21st.
Don't keep it on Monday. Monday will be, my lord, extremely difficult situation.
Best day, Mr. Chatterjee. The matter can be hard on merits on that day. You wanted that.
My lord, Monday, my lord, matter can be thrashed out, but we will be thrashed out on road.
You said we will not take much time.
Well, in road, my lord, we will be thrashed out. In road, while coming.
Virtually, it can be done. No problem.
21st July,
Virtually, it can be done. Mr. Chaturvedi also can
Resolution
appear virtually. No problem.
Kindly keeps it on Tuesday.
Next week,
No, Tuesday, my lord. Kindly keeps it on Tuesday.
Yes.
Tuesday.
No, Article 13, Lord, I am appearing, Lord. This is the same, against the same order, Lord. I have challenged also.
Who is appearing?
Hospital.
I'm for the hospital.
Chatterjee appears for
the
same
matter. The same matter against the same order, Lord. The hospital.
Chatterjee is also appearing in the other matter.
One matter will solve because these are the same. One hospital, one doctor.
Against the same order.
Different compensation.
No, yes. Amount varies.
Amount is different.
Amount varies.
Doctor personally liable, hospital vicariously held liable, separate compensations imposed.
Can it not be sorted out amongst yourselves, Mr. Chatterjee?
But the allegations.
Chaturvedi, you are here. Can it not be anything?
Well, I think the offer should come from them.
Yes.
Lord, I'll take instructions to that also. But Millard, only thing, Millard, he's very renowned doctor. All medical boards have said as best possible, Millard, treatment has been given.
Mr. Chatterjee, that is on merits.
Yes.
That's
why I said, Millard, I need to take some. If I had found some glitches, I would have.
I've given you 1 week's time.
Right.
Same order.
Same order.
Yes, next.
Number 40.
Yes.
I'm for the petitioner.
Yes.
Petitioner before your honor is a defendant number 1 or wife of the plaintiff. Plaintiff files.
Wife of the plaintiff.
Plaintiff, yes. Plaintiff files the one declaration of permanent injunction against the petitioner.
Which is the order under challenge?
Hello. Come to order dated 7 May 2025.
7th May, what has been done? Interim injunction extended.
and come to the first.
Sir, it's an appellable order, sir.
Come once, plaintiff is absent
Yes,
without taking any steps.
yes,
Defendant also files Hajira along with an adjournment petition. Adjournment petition filed by the other defendant, pro bono defendant, not me. On repeated call, none appear on behalf of the plaintiff. Prayer of adjournment is considered and allowed. Fixed 29/7/2025 hearing injunction petition, WO if any in the meantime.
yes,
On later at 4 p.m. Plaintiff file an extension petition of ad interim order of injunction, copy not served. Heard advocate for the plaintiff, peruse the petition, praise, consider and allowed ad interim of injunction hereby extended.
yes.
He has filed the extension at the 4 p.m. without serving us, without our knowledge.
So extension appellable order. Order passed under Order 39, Rule 1 and 2, even extensions are appellable order. And what is the other order which you are challenging? 2nd of August. That is also directing maintenance status quo. That is also an appellable order. This ad interim is continuing. You are the defendant. You have filed your written objection. So 29th of July is the date fixed for hearing. I am directing the injunction application to be heard out on that date. After some argument, the learned advocate appearing for the petitioner.
But the plaintiff is the petitioner before your lordship.
Yes.
Initially, an ad interim order of injunction has been passed. My lord's brief below page 17. 17.
Yes.
My title deed. The initial
no caveat.
Initial title deed, thereafter conversion. The permission granted by the local Gram Panchayat, everything considered, and ultimately defendant were being restrained from interfering with the construction work of the plaintiff. That is the order of injunction. Page 17 and 18, if your lordship takes up, the 18, your lordship will find considering the prima facie case, the defendant are hereby restrained from causing obstruction in the construction work of the plaintiff over the suit property and or from changing the nature and character of the same till 5th of July.
Ad interim order.
Ad interim order. Now, if your lordship kindly takes up, no written objection, no vacating application. Straight away appeal.
It is permissible, Mr. Mukherjee.
It's permissible. There are three ways. One of the ways is that. Now, before the appellate court, the last certified copy my lord would get, they have taken the ground of suppression. What suppression? A previous suit was there wherein my husband was being restrained. But the restraint order is with respect to the nature, character and possession, not for transfer alienation. So ultimately, they gifted the property has my husband in my favor. And I, after making conversion, property tax clearance,
when the earlier suit, when the order of injunction was passed,
kindly takes up the impugned order. The earlier suit,
Please
Milord,
give me the dates.
yes, 19th of May 2023.
19th of May 2023 in the earlier suit.
Earlier suit.
Order of injunction passed. Or
Order of
status quo?
injunction not against me. Status quo, not against
Not
me.
against you, your husband.
Yes.
Order of status quo.
Status quo.
Status quo.
That has
Pass.
been quoted. Nature, character, and possession. Learned
Earlier order.
appellate court quoted that.
Acha, yes, in that suit, when your husband appeared,
Milord, it has been quoted in the order that on 23rd of May 2023, the order has been communicated. Milord, I do not know, Milord, the plain case does not disclose anything on this. Because today we are in challenge to the ad interim, Milord.
yes, 23rd of May,
That has
order
been
was communicated. Yes, then what did your husband do in that, and when you have got this property?
Milord, I have got on 2nd of June 2023.
2nd of June 2023, petitioner acquired title.
Mine.
So, transferred in favor of wife.
Thereafter, Milord, the conversion made, Milord, the plans applied, plan obtained, everything is, Milord, on record. And I made construction up to window level, Milord, after plinth, Milord, everything, Milord, up to window level, even brickworks completed. That has been quoted, Milord, in the trial court's order. Now, that trial court order, Milord, I have shown before your lordship, that passed on 2023. The appeal disposed of on 23rd December 2024, considering that since this plaintiff case, Milord, the pendency of that suit, Milord, wherein my husband is the, Milord, party, that has been suppressed, so I am not entitled to any order of injunction. My ad interim injunction has been, Milord, your lordship knows the concept of, Milord, the Jitesh Pandey, Milord, the exactly similar case. Pendency of an earlier suit is being canvassed for the first time before the appellate court. The appellate court vacated the order of injunction, allowed the misappeal. They came up in this revisional court jurisdiction. This revisional court found no. This is not a forum where you should agitate. If you want to challenge an ad interim order, you have to take the plain case as a sacrosanct. And thereafter, the scope, Milord, the three of.
What is the other view, Mr. Mukherjee?
Milord, the Jitesh Pandey is, Milord.
Other view is also there.
But kindly takes up, Milord, the Jitesh Pandey, Milord, that is, Milord, the consistent.
The other view, there is no other view of a division bench.
Milord,
where is that judgment?
Milord, even 2017, Jitesh Pandey has been followed by the
other judgment is also there.
By the division bench of the.
Where is the other judgment?
But Milord, here is a case, Milord, where the court cannot go into, Milord, this aspect at the.
Facts are very ugly, Mr. Mukherjee.
Otherwise, Milord, this.
Facts are very ugly.
Milord, kindly.
Facts are very ugly. From the dates, it appears that your husband, knowing fully well, has transferred in order to bypass the order of injunction.
Milord, the order of injunction.
It's an equitable relief, Mr. Mukherjee.
I know, Milord, it's an equitable relief, but Milord, kindly consider, Milord, they can appear before the trial court and thrash it out whether, Milord,
I'm directing the injunction application to
only one thing. Kindly consider one aspect.
If the injunction application is heard, Mr. Mukherjee, all facts can be taken.
Only one aspect the court has gone into as if my husband has transferred the property in teeth of an order of injunction. That is not correct. But I have shown before your lordship. Lispendence is something, Milord, which is, Milord, it is not a document to be said to be void. It will carry, Milord, whatever the result of the suit, Milord, that.
I am directing the temporary injunction application to be disposed of because
but Milord, with this observation, if Milord, this observation remains,
Mr. Mukherjee, ad interim and temporary considerations are entirely different. Both the parties will place their materials.
Kindly, Milord, mention that without sweating, Milord, any of the observation.
Temporary is dismissed. Yes, ordering part.
The Milord, the interim in. Oh,
temporary injunction.
That cannot be. Kindly, Milord. Then, Milord, I will have to serve.
You have to.
I have missed this because ad interim challenge. Temporary injunction to dismiss.
Ad interim or temporary challenge?
Ad interim. Milord, kindly takes up the order is, Milord, we have been temporary 5th of June order. I have shown before your lordship 5th of June order. 5th of June is at page 17 and 18. compliance has been directed to the made below 39.3 AB by 5th of June.
What is the next date? Oh, temporary is dismissed, then to it cannot be. Coming after 5 minutes.
Item number 16.
16, my lord, I am for the petitioner.
Yes.
My lord, in a suit for declaration and injunction, my lord, I am the plaintiff.
Yes.
My lord, the suit was, my lord, fixed for PH. My lord, it got adjourned on repeated occasions, my lord, due to different reasons altogether. My lord, not entirely because of me. My lord, the learned court had, my lord, kindly, my lord, takes up the order impugned, my lord, 19th of June. My lord, I've annexed the entire order sheet, my lord, so that, my lord, the dates can be, my lord, checked up. My lord, 19th of June, my lord, the court, my lord, states several dates, puts the blame upon me, my lord, closes my PH. My lord, kindly considers, my lord, the dates, my lord. Now I, my lord.
How much cost for each day?
No, terms, my lord.
2,000 for each day of adjournment.
My lord, kindly considers, my lord, I've, my lord, pleaded, my lord, in my paragraph, my lord, page number 3 onwards, my lord, the reasons of adjournment.
15.
Local bar association.
15. Yes.
My lord, kindly,
15.
my lord, cost, my lord, I cannot negotiate, my lord, on the cost. But, my lord, kindly considers, my lord, only one aspect. My lord, paragraph number 4 onwards, I pleaded the reasons. My lord, the entire order sheet also is also annexed herein. My lord, the matter was adjourned for resolution of the bar on 4 occasions. My lord, the court employees abstained from work, my lord, on 3 occasions. My lord, the defendants, my lord, put up, my lord, their adjournment application on certain dates. My lord, the entire blame, my lord, cannot be put upon me, my lord. My lord, certainly I am at, my lord, blame here, but, my lord, not the entire blame.
By the order impugned.
The suit for my lord. This is partition and other reliefs, my lord. And the road and my lord sisters file an application. 2 sisters, my lord, file the suit for partition. And father
petition. Thereafter, what happened?
Therefore, my lord,
what is the impugned order?
It is the admission on admission, my lord, for judgment for one admission. The plaintiff number 2 also made an application, page, my lord, 49 and 50. And earlier, my lord, father, my lord, transferred the property 28 bighas of land out of 32 bighas by all the sons and.
No, what is the judgment on admission? Show me the admission.
Yes.
Show me.
Page, my lord, 49.
Page 49. What is page 49?
That is plaintiff number 2 stated the, my lord, admitted the facts that the, my lord, partition admitted the fact that he never filed an application on the by respondent number 4, my lord.
I could not follow you.
And my lord,
page 70 is the plaint. Show me the admission on which you want judgment on admission. Show me the admissions in the plaint or any other documents.
Plain, my lord, denied that I am the owner. And my lord, page 40
the admission.
And 49 says, my lord, if you lordship, the plaintiff is stated by filing a petition, kindly see page 49.
49, yes.
The one of the, my lord, plaintiff filed an application before the learned court.
Yes.
And he admitted that his father, my lord, transferred all the deeds in favor of the sons and daughters, except, my lord, respondent number, defendant number 4. And he admitted, my lord, kindly see, my lord, page, my lord, 49.
Portion? Page 49, which portion?
49 and 50, if you lordship, my lord. 59 middle portion. যেহেতু কোরবান আলী মন্ডল তাহার বড় ছেলে হেদায়েতুন্নেসা বিবাহ জমিদার পরিবারে দিয়েছেন এবং 2 নম্বর বাদিনীকে গ্রামের বিবাহ দিয়া প্রথম ঘর বাড়ি তৈরি করে দিয়েছেন এবং উক্ত সেহেতু তিনি 6 নম্বর বিধবা বিধানে বিনোদিনী মৃত্যু ফাজেরা খাতুনের 4 ছেলেকে 18 থেকে
So
21
what is
নম্বর
the admission? Please tell me. What is the
Admission, my lord.
admission? Don't read that thing. What is the admission?
admission, my lord, the deed was, gift deed was admitted that all, my lord, transferred by gift deed. If the gift deed is admitted, plain, my lord, no
Who
deed
was the original owner?
owner, my lord, Korban Ali Mondol.
Korban Ali Mondol.
Yes.
What is the plaint case?
Plain case, my lord, the two daughters, my lord, file a suit.
Yes.
File a suit that I did not get any share.
Yes.
And file a suit. Because, my lord, the plaintiff number 2 also got the share, got the property by gift deed. And, my lord, he stated the, my lord, specific fact, and other sons was also, Korban Ali, my lord, transferred to the all sons and daughters. And the plaintiff number 2 also, 49 and 50, also admitted the same. Fifty and 51. And 51, if you lord's my lord, page. Thereafter, my lord, the impugn order, my lord, if you lord's.
Yes.
He says, my lord, that is stating the facts, my lord. That is the enter the PW2 also admitted. And, my lord, Korban Ali, my lord, transferred the suit property to his sons and daughters. Only, my lord, out of 28 bighas of land, out of 32 bighas. Only 4 bighas land, my lord, has been, my lord, left. And his share, my lord, 113. To 113 is share.
No, in the plaint,
yes,
the plaintiff number 2 states that she has also got share by way of inheritance. Now, now in the if she filed an application stating that no,
Korban Ali.
So this not clear and unambiguous admission is not there. Admissions are to be clear. So on one hand she says by way of inheritance, other hand she says which is to be taken as admission.
But on the, my lord,
Order 12 Rule 6 has to be clear, unambiguous. So there are two things.
But, my lord, if you lordship, my lord, he also when he stated, my file
Take that advantage of that admission in the trial. This application under Article 227 of the Constitution.
in this matter, I am appearing for the plaintiff petitioners. This petitioners, my lord, belonging to senior city to early disposal of the suit, title suit, my lord, 87 of 2021. Suit for partition and permanent injunction against the defendants. And the last order, my lord, in respect of SR report on 13th August 2025 for service in favor of the defendant number 14. It is not postal receipt, is not written. So 2000, these petitioners, my plaintiff petitioners, my lord, are aged about 81, 84 and 63 and 62.
Mukherjee, unless the service is complete, no directions for
Rightly, I have already I have submitted before your lordship, my lord.
You take steps for effecting service, otherwise at
Effecting,
least.
my lord, kindly see, my lord, the defendant number, last order, my lord, kindly.
Yes, I have seen. 13th of
Yes,
August for
yes.
service returns.
Yes, service return in favor of, my lord,
Defendant number 14.
service, but
Unless the service is complete, suit is cannot be said to be ready for hearing. No directions. Full stop.
only for, my lord, the
My application. My lord, I'm challenging two orders of the trial court. My lord, this suit for specific performance. My lord, in this suit, your lordship, I am for the defendant, my lord. My lord, this suit is now converted into commercial division, your lordship. After transfer to commercial division, plaintiff filed two applications under Order 11, Rule 12 for discovery of documents and 14, 15, and 16 for production of the original document.
Yes.
My lord, I have made an application before the trial court that either give me time, I'm seeking time to file my opposition because your lordship, opposite ground.
Opposition to what?
Of those two applications, your lordship. Of those two applications.
What are the two applications?
My lord, one application is for order under Order 11, Rule 12 for discovery of documents and Order 11, Rule 14, 16, 15 for production of original documents, your lordship. I have to seek a time for filing opposition, your lordship. My lord, the reason of your objection, my lord, that this is
what happened to that?
Rejected. That was rejected.
What is that?
Lordship, kindly come to
which order?
Page 62. Page 62 of my application, your lordship. The order, the impugned order.
62. What is the order dated?
Order dated on 15th of February 2021, your lordship.
15th. How can you challenge that order now?
My lord, may I? But thereafter, I filed an application for recalling of the order, your lordship. That was also rejected, my lord.
Rightly rejected.
But
15th of February 2021.
Well,
you have filed the application for recalling when?
Immediately after the order of pass, your lordship. Kindly come to.
On what ground?
My lord, there are lots of grounds. There are most important ground is your lordship. This is a commercial suit, your lordship. This application under Order 11, Rule 12 and 14, Rule 14, 15 and 16 is not applicable, your lordship. The commercial court act is saying, your lordship, that the procedure laid down in the amended commercial provision CPC should be followed, your lordship.
When the suit was transferred?
2020, sometime in the 2020, your lordship.
Yes.
Subsequently, this application was filed.
Yes.
My lord, I have specifically pointed out to the trial court that this application is not maintainable, my lord. That was not recorded, your lordship. And I also seek a short time to file opposition, your lordship, to that effect.
Show me that you have raised that point in that order.
My lord, order was not, my lord, kindly come to page 62 of my application, your lordship.
No, application you may have taken. Show
No,
me
my
from the
order, lordship. Lordship, kindly come to page 62, your lordship, for once.
What is the 62?
The impugned order. I have
impugned order. I have the certified copy. Place from.
Oh, my lord. My lord, kindly come to. Yes, kindly come to the last paragraph of the first page of the order, your lordship. After I have several objections, your lordship. that per contra, the defendant contends that the instant suit filed by the plaintiff petition specific performance of contract and suit was now proceed to evidence stage. The plaintiff petitioner filed an affidavit in chief from so and so without supplying the copy so and so. Thereafter, the incident so and so suit was fixed for preliminary hearing on a consecutive date so and so owing to COVID-19 situation so and so. After puja vacation, the next date on so and so, peremptory or hearing was so and so fixed on so and so. Application under order 11 rule 14, 15, 16 and another application under order 11 rule 12 has been belatedly filed by the plaintiff petitioner. The plaintiff petitioner has failed to maintain any cognate reason as to why had the prevented the application so and so exhibits.
So that was not your contention. Amended provision, old provision.
Next paragraph, the provision of Commercial Codes Act 2015 are applicable to the instant application. Plaintiff is attempting to file an document at a belated stage, which is impermissible under the said act. The court is required to adhere to the said provision and dismiss the application, Your Lordship. And then, interestingly, the trial court quoted the provision, the wrong provision, and allowed the application, Your Lordship, without giving me opportunity to express my entire legal point, Your Lordship. Would you kindly come to the findings of the trial court?
Yes. What is the provision in the Commercial Codes Act?
Would you kindly, the order 11, rule 5 is the only application on. Order 11, the amended provision of the Commercial Codes Act, the order 11, rule sub-rule 1 and 5 is for production of additional document lies in the favor of the plaintiff. But order 5 only giving the production of documents, Your Lordship. And this is.
No, I could not follow you.
Lordship, order 11, rule 5, commercial amendment of the amended provision, Your Lordship.
Yes.
Yes. Your Lordship, kindly, first I will indicate the rule 5 for once.
Rule 5 or order 11?
Order 11, rule 5.
Yes.
Now, production of documents, Your Lordship.
Yes.
Yes. It has this principle has given the procedure how to follow the proceedings to production of additional document. Production of documents, Your Lordship. And my Lord, if a Lordship place the general provision of CPC, Your Lordship, that rule 12 is for discovery of production, and the procedure is written, my Lord, that is completely different, Your Lordship. May I place the rule 12 of the general provision of CPC, Your Lordship, so that I can.
Yes, order 11, rule 5, it permits.
Yes.
At any time during the pendency of the courts.
Yes. But the Lordship, the application should be in that way first. Second, Your Lordship.
Show me the application.
Lordship. Lordship, kindly come to page 50 of my application, Your Lordship.
Page 50, yes.
Lordship, this is the first application that was filed, Your Lordship. The nomenclature indicates the humble application under order 11, rule 14, 15 and 16, the Code of Civil Procedure on behalf of the plaintiff. Lordship, and sought for several documents. Though those documents are not in my custody, that is another point of argument, Your Lordship. But this application is under general provision of the CPC, Your Lordship. And the subsequent application, another application is also similar at page 57.
So what is the difference between general provision and the Commercial Codes Act?
My Lord, well, in general provision, Your Lordship, if I indicate, Your Lordship, the general provision order 12.
Tell me, what is the difference in the general provision and the Commercial Codes Act provision?
My Lord, if I indicate, Your Lordship, that production of documents, Your Lordship, asking for under order 12, order 11, rule 12, Your Lordship, it is saying it is saying that documents can be and any application can be filed without any affidavit and sought for the documents, and court is fixed, deems fair and so, Your Lordship. That is
where affidavit has been filed. Here, affidavit has been filed.
Yeah. Lordship, rule 5, it's indicating rule 5.
No, I am asking you, what is the difference? Indicate the difference.
Yes, rule order 12 does not say there is a procedure, have to follow the procedure of form that documents which require to be production of documents has to follow the procedure in form 7 in appendix C of the Code of Civil Procedure, Your Lordship. Rule 12 does not say so, Your Lordship. Rule 12 is says only saying any party.
That is your difficulty. Form is the technical part.
My lord,
Form is the technical part. When the application is being filed, they indicate what are the documents.
Very well.
Form is technical.
Very well, lordship. Then my lord.
Then the more so when the suit has been transferred from the ordinary court to the commercial court.
But that is after this application filed after.
I appreciate your submission.
And secondly,
Form,
lordship,
yes.
my lord,
Any other thing?
The commercial court that is saying, lordship, section 16, subsection 3, if there is a conflict between CPC or the general provision and the amended provision of the commercial lordship, commercial court will prevail.
Yes. No doubt about that.
Okay.
Yes.
And now, my lord, if your lordship kindly come to the application of what the document are actually short for.
Yes.
May I indicate your lordship that why I'm asking for the opposition, your lordship, before the trial court.
Is it in your custody? Yes or no?
No.
Say that.
But that have to for that.
Where have you said that it is not in your custody? Show me in the impugned order you have said that it is not in your custody.
Not recorded. My submission is not recorded.
Then file a review application before that.
My lord,
you have said that it was not with you. It was not recorded.
But
the provision is that.
That has.
I think that is the law.
Opportunity should be given to me to find my opposition.
I'm giving you an opportunity to withdraw this. Approach that court by a review application saying that.
Since it is a commercial court, my lord, it has since it is a commercial.
Sir, according to you, those documents are not lying before you, with you, and you have stated that the learned judge of the commercial court did not take note of that. Say that before that court.
But your lordship, in that
I cannot decide that whether you have said or not.
But your lordship, I shot direction from leave of the court to file my opposition. That was not done.
By which order you sought a leave for filing opposition? Which order records that?
Nothing is recorded. My application is there. My application is there.
What application?
My lord, my application for I shot a leave to file an opposition, your lordship.
That is there. No, sir, you may have filed an application for leave.
That was a
Only that when this matter was taken up, you said that I want to file opposition.
My lord,
sir, let us take up.
My lord.
A matter civil revision application is being taken up. Now you are for the opposite party. The matter is hard. Now you say, yes, I want to file opposition. I told that.
No, my lord. My lord,
show me. That is why I'm asking you. Show me.
If you lordship see the dates of the application, the affidavit I have filed, that affidavit filed before passing of this order into an order, your lordship.
Maybe.
But lordship,
where is that affidavit?
My lord.
Show me that.
Page 60, your lordship, of my application.
60?
Yes, your lordship.
Yes.
Lordship, can you see the date of my application, your lordship? Affidavit file. My lord, lordship, can you see they were filed by 15th February 2021?
Show me that you have stated that those documents are not in your custody. Show me. Show me in this application.
My lord, in this application, I have short. My lord, kindly see the preamble of this application with a humble petition on behalf of the defendant seeking leave to file written objection. Lord, at
Page
least
60.
Page 60, your lord.
Yes.
At least time to file an objection. But to
what prevented you from saying that those documents are not in your custody in this application?
My lord, that I only get a time to express my entire thing on your opposition, your lordship.
So your entire endeavor is to take time. 2021 order, 2025 recalling, revision, reopen 2021.
In this application, I have filed application for expeditious disposal of this application. That is your lordship passed the order, your lordship.
Then you are delaying.
I'm not delaying your lordship, but the lordship that
comply with that.
Well, how could I comply with your lordship? Well, how could I comply, lordship? Because if I fail to produce,
withdraw this, file a review, saying that I've sought for time to file objection you have not given.
Well,
tell that.
Well, I didn't file my review application. That's fine. That is true. My lord, I didn't file my written objection.
Do that.
But
everything you can make that.
Application. I have filed recalling application, my lord. And well, this is a point of law that my lord.
Show me your recalling application.
Yes.
What have you stated? What is the ground of recalling? Show me.
Lordship, page 65.
Yes.
Lordship,
that you have stated here that those documents are not with you.
The public, I have stated in public domain. It's available in public domain. So I have stated that.
So take it out from the public domain. Produce that. Take it out from the public domain. Produce that.
Well, how could I place the original direction for placing the original documents, your lordship? The order passed by any court that is not that original could not be with me. That should be in the I have to make an application before the appropriate court for get a certified copy, my lord. How could I give that? A tender document issued by someone third party. How could I get the original?
Sir, subparagraph G. What do you say to this? Page 66, subparagraph G.
Furthermore, there are some documents which are related to very old records, and there has been exchange of manpower transfer so and so.
So you admit that you have the documents, you did
My
time.
only I have a minutes that between plaintiff and the defendant. But my lord, the tender
Produce
document.
Produce
And
those
my lord,
documents.
if I take it, your lordship, since your lordship saying it's a technical position of placing the rules and regulations, your lordship.
66G.
Yes,
You
your
have
lordship,
not
yes, your
said that it is not in your custody.
Lordship, if your lordship kindly see all the documents that they short for, the only one document apart from that, others are all with the third party, your lordship. But a tender document, how could be with me an original one? I may be the tenderer. I have participated in the tender, but that document is not with me, your lordship. This document was with the tendering issuing authority. And when the orders passed by the relevant courts, how could I get the original copy of those orders, your lordship? The letters issued by the third party, how could I get the original letters of those letters, your lordship? And if I fail to produce the document, that will give a negative inference on me, your lordship.
Has to.
That is the rule. That is rule of the.
law.
That law you apply to me, but why not the strict procedure would not apply to the plaintiff, your lordship?
Yes. You could have challenged that 2021 order immediately.
But I have immediate action, my lord. Immediately I have filed recalling application, your lordship.
Show me that recalling was only on that ground. You could have, sir, under what grounds recalling is permissible? When an order is passed on a contested hearing, what are the limited grounds for which recall is allowed? It's not on merit, sir.
Yes, your lordship.
So,
but my lord,
show me what is the ground. You have stated those on merits and you have paid for recalling. Contested hearing, recalling is not permissible on that.
Not giving the opportunity of filing opposition, your lordship, that is violation of natural justice, your lordship. But if I got an opportunity
for that, please approach that court, take it, review, withdraw this, file an application there. That in spite of making those submission, court did not record that.
After all this review, now if I say to file a review application, that it's all a time body, your lordship.
Sir, you have to take that responsibility. Who made that submission before the court? That person has to take a responsibility.
This court under Article 227 has a immense power.
It's very easy to go before another forum and say, I said this there. It's very easy.
But wait, your lordship. But your lordship, thing is, lordship, if I make anything in the air, but the thing is, your lordship, I have filed my application for sort of time to file my opposition, your lordship. That opportunity was given, but without giving any opportunity, decide the case. But that is the violation of my right, your lordship. I could have pleaded everything if I get an opportunity to file my opposition, your lordship. That was not given to me. Well, that is not a violation, your lordship.
Sir, if you want, I can give you that liberty, or I will proceed on this basis of this. If you say that you paid for that and that opportunity was.
Lordship, then my lord, my suggestion, your lordship, if my lordship, it is fallen from your lordship to file a review application.
I'm not saying anything. I'm not saying. Since you are saying that you said that, that's the law. I'm not saying anything. Please make your submissions. Don't say that the court has directed this.
But your lordship, since if I make
you move your on merits, I will consider that. You move on merits.
But first, where your lordship? Where your lordship? Lordship, may place it on merit, your lordship. Lordship, yes. First, your lordship, then your lordship kindly come to first their application for once.
Yes.
In their application, they short. What are the pleading of
page is their application?
Page 50.
50.
Yes, your lordship.
Yes.
Page 50, I am indicating, your lordship, their admitted position that they have the plaintiff file and paragraph not I'm reading, your lordship. I'm reading out from paragraph 3, your lordship. The plaintiff company categorically stated to filing original documents aligned with the custody of the defendant number 1, and the plaintiff's company respectfully submitted before your honor to give a direction upon the defendant number 1 to produce the following original documents before your honor court, and also prayed for the honor to consider the documents exhibited documents. They want to exhibit documents and documents aligning with me. The documents are the tender document which is published by the Bengal Immunity Limited, short form so and so, and for selling of its one of the properties, premises number so and so, your lordship. But the original tender copy, how could it be with me, your lordship? It is floated by lord. I have maybe I'm the tenderer. Next, your lordship, the tender notice on so and so, but the tender notice was issued. My lord, how could I get it original with me, your lordship? The next one, Lordship, the letter dated so and so by the Bengal Immunity Limited to the reference number 1 HSCL. Well, how could I get the original one, Lordship? It was issued to me, your Lordship, or lying with the third party, your Lordship. Again, the affidavit of affirmed on 24th September 2024 filed by the HSCL in CA. My lord, in affidavit I have filed in any court, that original should be lying with the court. How could I get the original one, your Lordship? The application being so and so, arising from so and so, BIFR case number so and so, affirm on 30 January 2006, filed by different number 1 before the namely HSCL against the different number 2, namely original official liquidator, my lord. Well, this is again an application that is original lying with the court, your lordship. How could I get that document, your lordship, the original one? Next, your lordship, the letter dated so and so by the advocate of the defendant, defendant number 1, addressing the official liquidator for payment of the balance consideration money, your lordship. The original lying with the official liquidator, your lordship. How could I get the original letter, your lordship? Second, your lordship, the application affirmed application of affidavit dated so and so filed by the HSCL in CA number so and so before the BIFR, your lordship. Again, the application affidavit application. How could I get the affidavit application with me, original with me, your lordship? That should be a photocopy only. The opportunity should be given to express myself before the trial court. That was not given to me. The order dated 6th April 2006 in number so and so passed by the Honorable High Court at Calcutta, wherein the Honorable Court was pleased to so and so. But this order, how could I get the original order, my lord? I have the copy, and if he wants to produce anything or rely on anything, he has to his responsibility to obtain certified copy, your lord, from this court, your lordship, because he was also party of the writ petition, your lordship. The order dated so and so, your lordship. Again, the order, my lord. Only the minutes, your lordship, the minutes of meeting held by the HSCL office between the plaintiff and the HSCL, lordship. These minutes I have with me that I can produce. But otherwise, other documents, so the orders, application.
Which are the documents which you have on this?
Well, on this, only minutes I have with me.
Produce that minutes.
And others, your lordship. Then, lordship,
produce that minutes.
And before your lordship. Before your lordship.
No. Before the learned trial.
Then lordship, my suggestion, lordship, then protect me from other inference of the court taking.
No. Please first produce. What are the documents which you can produce? Please tell me.
The minutes that was between me and
only between that.
Only original one. How could I get the other order date?
No. Which? Please tell me from this which of the documents which you can produce.
Only maybe the minutes that was executed between me and the plaintiff. That's the original one with me.
Yes.
But other documents, how could I produce the original one, your lordship? And well, it is
item number.
This
item number 11.
Item number.
Page 53. Item number 11. You can produce.
That so far I have information that it was executed. Since it was executed between the plaintiff and the petitioner. That for that I have to take.
And item number 12. Why can you cannot produce this? Different number 1 intended not to proceed any proceedings against the official liquidator. This you cannot produce.
Order dated. Order. How could I give an original order, your lordship?
Such certified copy. Nobody is saying. You can produce the certified copy.
But I have to apply for that, your lordship.
Yes.
And it is putting a burden on me, but the responsibility of plaintiff to
BIFR. These BIFR proceeding was between whom? For whose BIFR?
Between Bengal immunity against the Bengal immunity, your lordship.
Yes.
I was participated as the tenderer to buy a property.
Yes.
Well,
which of the documents you have? Please let me take note of
that. I have to take instruction, but
please take instructions. Come. Which of the documents which you can produce? The learned advocate appearing for the petitioner submit. Please take instructions, which of the documents you
My lord,
can
my lord, this is
produce?
21st July, your lordship. That would be difficult, my lord. For the practical reason, your lordship. 27 is, my lord, 22nd, your lordship.
23rd করে দিন। Yes, call the next matter. Matter number 20.
Hello, in this matter, I'm requesting for not this week in this matter, Your Honor.
Why, sir? What is this matter?
Planet advocate in this for petitioner is suffering for fever, so he couldn't attend the Lanet court for this week.
On the prayer of the learned advocate for the number 21.
Item number 21, I appear for the Eastern Coalfields, my lord. I have
I appear on
instructions to
behalf of
appear
the
in this
petitioner.
matter, my
I
lord.
mean, led by
Eastern Coalfields.
no copy.
My lord, no
Yes.
copy of the civil
My lord,
revision
no
has been.
caveat has been lost, my lord. That's why, my lord, no copy has been
Let
sought.
them, let
My
the
lord, no
petitioner
caveat has
direct,
been lost.
supply a copy to the.
Yes.
Lord, by the impugned order, what has happened? Lord, my learned friend's client has filed a suit, money suit against me, my lord, in a commercial division.
Yes.
Now, my lord, without complying the mandatory provision of section 12A, my lord, they have proceeded with the suit. Now, my lord, they had filed an application for leave, seeking leave under section 12A. My lord, by the impugned order, that leave has been allowed.
By the impugned order, leave has been allowed.
Yes.
Show me that. No, this is for revocation. What are you saying?
Yes, my application for revocation of the leave. That has been dismissed, my application.
Don't say by this order leave was granted. Leave must have been granted earlier.
Yes, leave
You have
was
sought for
granted earlier.
revocation of that leave. Show me the order granting leave.
This is the first order, my lord. Page 500, my lord. Volume
500.
Volume 3, my lord. 21st of January 2025.
What are the documents which you have annexed, Mr. Mondal, in this civil division application?
Lord, along with all annexed, plaint along with all annexed.
All right.
There was a
500.
Yes. Volume 3, my lord.
Well, show me the plaint first.
Plaint is at
Plaint, prayer.
Plaint is at page 315, my lord.
315.
315. Volume 2. Prayers are at page 326.
What is the suit for? Mukherjee, you are appearing. Mr. Mukherjee, if this is the suit for, where is the contemplation of urgent relief?
That's where I am on. 12 capital is very specific, my lord. The plaintiff has to contend that. And the cause of action, my lord, has shown. But it is something, my lord, it's not.
How could you obtain a leave under 12A?
Let them supply a copy, my lord. Let me go through the, my lord. We'll come back before your lordship. We will assist your lordship. Let them supply a copy of the civil revisional application.
No, my lord, they are not in caveat. No, I shall definitely serve them copy, my lord, without copy being
served. Mr. Mukherjee, what is the effect of revocation of leave?
Revocation, my lord, the
leave was wrongly.
Lord, the Honorable Supreme Court is now saying this is in 2025. This is mandatory. 7-11.
Mandatory in particular automation, it has been said. Mandatory from which date?
Yes,
This
yes.
will.
My lord is
so that's the parent judgment. So don't say in 2025. Held to be mandatory in that judgment itself. I'm not asking you that. I'm not asking you that whether it is mandatory. I'm asking you. Leave has been granted rightly or wrongly. Now, leave is revoked. What will be the effect of that?
Effect, suit goes. That is below the judgment.
Suit goes means
they will have to again litigation mediation. They will have to.
No, what will happen to the suit? I'm asking you. Suit will be dismissed. Plaint will be rejected. What will be the effect? Show me from the provision.
This effect is below the Supreme Court is saying the Order 7, Rule 11 will be attracted. Suit will go. The
plaint will be rejected. Don't say suit will go.
No, the plaint will be rejected.
Yes. Show me that judgment.
Yes, judgment. Kindly takes up this, because this 2025 SCC online, this has been taken care of every aspect. I will not trouble your lordship. Entirety kindly takes up the conclusion part, paragraph 62, last but one page. Patil automation, my lord, which judgment my lord is just now referring, that
has been considered in page paragraph 59.
And 62 is the conclusion.
Yes.
62, it has been stated that prior to 2022, that Patil automation has not came into force. The suit will be suspended. The parties will be relegated to first, not
that is
resource.
Yes. 20th of August 2022.
Yes. But after that,
that is what I have told you.
After that, 711.
After that, what will happen? Yes, court shall keep the suit in abeyance.
Yes.
So it's not rejection. That is why I asked you.
That is Milord prior to.
No.
Point number J, Milord kindly takes up. In a suit instituted
Prior
without,
to, and what is the after?
After, that's right, J. Point number J, paragraph 62. In suits instituted without compliance 12A of 2015 Act prior to such as such, which are pending
What is
adjudication.
post?
Post, Milord? Yes.
What is post?
Yes, Milord, 63, paragraph 63. A. If a suit instituted on or after the date of decision of such and such, that is without complying in the 12A of the, then it must make the rejection under Order 7, Rule 11, either on an application by the defendant or suo motu by the court. So that's where the Supreme Court has taken a distinction. If it is prior, arrested,
that is why I asked you what will be the effect.
Yes.
So this is the suit after 20th of August 2022.
Yes.
Suit does not contemplate any urgent relief. Show me the order granting leave.
Yes, my lord. Lord, its voluminous kindly takes up volume 3.
Now I'm used to these voluminous civil division applications. Yes. Page?
Not page. Lord, kindly takes up page 426. Order number 1, page 426. I must say, my lord, why I've taken out this short.
Now, what is the impugned order?
Impugned order, my lord, is the last certified.
What does it say on this?
On this, my lord, the previous judgment was being considered, and the court is of the opinion that since in
court did not consider Patil automation.
Patil automation, my lord, Yamini Mono.
Yes, Patil automation has been considered.
Yes.
Thereafter, what's the reasoning?
Court proceeded as if, my lord, the paragraph of the plaint is being quoted. The plaint does not contain any urgent relief, my lord, I have shown before your lordship. In the paragraph, some averments in a suit, my lord, instituted in a money, my lord, the claim is of monetary nature. So in such a suit, my lord, one averment of the paragraph has been considered. Kindly takes up, my lord, that portion of the learned judge's order impugned, paragraph 14, internal page 9 of the judgment, my lord, the impugned order. It's quoted paragraph 12, 20. Internal page 9 of the impugned order, paragraph 14.
Seek interim relief. But where is the interim relief which has been sought?
Lord, I argued even before the trial court, Lord, the language of section 12 is very categorical. The plaintiff has to contend it. Until today, they have
a copy.
Lord, only, Lord, protect me. 25th is the date fix of this month.
25th.
25th. Protect me for a limited period. I will come back, Lord.
Serve me a copy. I will take it up tomorrow.
Tomorrow?
Yes. What's the difficulty?
As your lordship, Lord, I cannot.
Day after tomorrow, my lord.
No.
My lord, kindly, my lord, day after tomorrow.
Then I am staying this. I will hear it after. If you can come tomorrow, all right. Otherwise, I have to stay. Because prima facie, has
My
to
lord will
stay.
kindly appreciate this. This is a PSU, my lord. We have to send the copy. We have to get the instructions, my lord.
All right, then because you have not lodged any caveat.
No.
So, by the order
Lord,
Yes, Mr. Ghosh.
Lord, is food for partition, Lord. Admitted position, Lord, both the parties have mighty share in respect of the entire property.
যেরকম আছে সেরকম থাকবে, ওই 2 নম্বরে চলে যাও।
Lord, admitted, it is a suit for partition.
Yes.
Lord, the admitted position is that the parties have mighty share in respect of the property. What happened, Lord, there is about 9 acres and odd land, including Bastu, Pukur, and Lord agricultural land. Lord, after filing of the suit, an interim order was passed directing the parties to maintain status quo in respect of Lord position and nature and character of the suit property. And immediately thereafter, an application for police help was also filed. It was allowed before Lord appearance. Thereafter, Lord, a commissioner was appointed. When I appeared, I Lord joined the commission. When the commission inspected the property, commissioner submitted a report whether any construction is going on or not. Commissioner submitted a report that a construction is going on in the suit property, that at my instance and in my portion. And Lord, what is the status of the construction, what is the position, everything
has indicated that.
Has indicated. And Lord, thereafter, Lord, I made an application under section 151 that allow me to complete the construction because this is the stage.
Up to what level it has proceeded?
Yes, Lord, kindly, it has been given by the commissioner's report itself.
Yes, where is that?
Lord, commissioner's report has not been included, but your lordship kindly see admitted position. I started construction before filing of the suit. Admitted position.
Yes.
And Lord,
Where is the commissioner's report?
Lord, I am taking. This is the commissioner's report, Lord, I am giving. And
now, what has been done by this impugned order?
By the impugned order, my application has been rejected.
Unfinished construction that has been rejected.
Yes. Lord, kindly see the commissioner's report. Your lordship kindly see, Lord. He has given the sketch map also. Question number 3, answer, and 4.
No, what is the extent of construction, Mr.
Lord, that has been given.
Where?
Height, what is the extent, everything has been given by the commissioner. Lord, kindly see the report. Question number 3 and 4, answer to question number 3
yes,
and 4.
Answer to question number 3 and 4. It says, active unfinished pakka construction রহিয়াছে উক্ত construction measurement নিম্ন বর্ণিত করিলাম.
Yes.
But up to what height? Oh, that is.
Yes, given.
উত্তরের দেয়াল.
Well, it is not that the one building, the two separate portion, the two brothers are there.
Not substantial. 6 feet and 3 feet. 6 feet is not much.
Lord, I have residential house, Lord, that is thatched house. That's why, Lord, your lordship, without claiming any equity, it can be done. And Lord, when the parties have equal share in the property, and the two separate portions.
Where is your application under 151?
Lord, that has been annexed, Lord. Page 21.
Page 21.
In last paragraph, I have given the extent of construction.
By the order impugned.
Yes.
The
Item number 23.
I am for the petitioner, my lord.
Yes.
The issue is with regard to a matrimonial suit, my lord. A matrimonial suit was filed, followed by an application for maintenance.
Yes.
And in the affidavit of assets and liabilities, I had served, I being the husband, had served the 3 years income tax file as per the Honorable Apex Court's direction in Rajneesh versus Neha. Now, my lord, after submission of that, my lord, the opposite parties had placed a request or a application that 10 years Form 26 IAS be asked from me. 10 years. Not even IT filed the calculation part, 10 years. My lord, learned court below gave a direction that it might be that gave a direction that the 10 years Form 26As be supplied to the other side. Malad, based on that, I had approached this Honorable High Court. Honorable High Court, hearing the matter, found that 10 years Form 26As to be unreasonable and brought it down to 5 years. I had submitted that 5 years also. 5 years from 18, 19, 20, 21, 22. On 2022, the suit was filed. My lord, on the last order, that's the impugned order, learned court below had directed me to file 3 more Form 26As for the last 3 years, going over and above the direction passed by the Honorable High Court, my lord. My lord, Annexure 50, page number 52 and 53.
For last 3 years from now.
From now, I had already filed 5 years. I have already filed.
You have filed that. That means this 3 years is covered.
No, my lord. Filing has been done from 18, 19,
Show
20.
me the High Court's order.
My lord, page number 52. 52 and 53, my lord.
No, you have submitted for till which period? For which?
Till 22, my lord. Till
22. That is prior to the filing.
Yes, my lord. As per.
Show me the order dated 23rd of August 2024.
My lord, page number 50.
50.
50 and 51, my lord.
No. Please kindly come to page 51.
My lord.
So this order was passed on 23rd of August 2024 for last 10 years.
For last 10.
So it is for 2024, 2023 and backwards from 2024. So, but you have filed for till 2022.
My lord, because in the order of the Honorable High Court, my lord,
Yes,
it's not
last
meant
5 years.
Yes.
So it has to be from that date. So you have chosen, you have kept this last 3 years.
It wasn't
Last 3 years, why are you avoiding? Please produce the, because current income has to be ascertained.
My lord,
Why are you shying away from producing this?
My lord, income as on the date of separation, as on the date of filing. My lord, that is for as per the direction of the Honorable Apex Court, my lord. Kindly see. I have kept that part. Because it is specifically directed, I have marked it.
Which point?
My lord, I have marked point number 7, my lord. Where the assessee of income tax 1 year prior to marriage, 1 year prior to separation, at the time of application of maintenance is filed. If the matter is, my lord, pending for 5 more years, obviously we are separated, my lord. So that is why I have.
So according to you, this change circumstances cannot be taken into consideration. I'm asking you. Has it been said that change circumstances cannot be taken into consideration?
There is no change circumstances, my lord.
So if you say for 5 years and a maintenance application is pending, the income will increase, but the maintenance will have to be on the basis of 5 years back income.
My lord, that is based on an interim application, my lord. She can anyway file another because I am already paying maintenance.
Sir, yes, she can file. What's the difficulty today? So if, let us please consider 5 years back an income. So then immediately on after 1 month, she will be coming and saying, yes, yes, for this, in the meantime, it has increased to some. Instead of that, if you file, it can be for
Just
once for
interim
all.
maintenance, my lord.
Yes.
It's just an-
Why are you shying away? Why are you shying away?
Because
Please
my lord,
produce that.
that goes against the honorable
But
appeal.
did not say that, said yes, till that date it is to be filed. Did not say that you need not file for the subsequent years. That has not been stated. What's the harm? Is anything there which you do not want to disclose?
No, it's not, my lord, it's not about
This,
being.
why are you challenging?
Placing the, I had filed the IT file, placing calculation part is also, it is the calculation part of entire thing, my lord. IT file I have placed, already placed, my lord. So. Let
IT file and 26As is a different thing altogether.
Yes, my lord, that is
So
why.
26As, what is there, you may not disclose in the your income tax return. Otherwise, this direction ought not to have been
But
passed.
I had already filed, my lord, for the 5 years as per the direction.
Yes, it's no difficulty. Why are you not filing for this present? Today we are on 25,
My lord, because that,
2025.
my lord, then it will.
I think another 26As has come.
That is why it is for the last
25,
years, my
24
lord.
and 23. That is why the court said, because court will be
a burden of me because
will be deciding that application in 2025.
my lord, I'll satisfy, my lord, because we have been staying separate.
All
from
right,
the year 2020.
petitioner, by the order.
Item number 24.
My lord, I am for the petitioner. My lord, the opposite party, husband, my lord, filed a matrimonial suit entirely praying for divorce under section 27 1D of the Special Marriage Act.
Yes.
To that, my lord, we have filed a section 36 application in praying for maintenance.
Yes.
That was allowed, my lord. I am challenging such order, my lord. They have come before this honorable court, my lord. Kindly consider page 13, my lord. Wherein, my lord, the honorable.
What is the impugned order?
My lord, without paying the maintenance pursuant to the order passed by the Honorable Justice Biswajit Basu, my lord, they are continuing with the main matter, my lord, fixing the date of evidence, my lord. My lord, only the area.
The maintenance is not paid. You have remedies. You exhaust that remedy.
But my lord, kindly consider Special Marriage Act, my lord. There is no such specific remedy, my lord, for execution.
What are you saying? What are you saying, sir? Execution is there. What are you trying to do by indirect way? That
My lord,
also you can
since
do.
the learned court is not trying to, my lord, interfere into the matter because, my lord, my kindly consider the page 13 order, my lord.
Which order you are challenging here?
My lord, I have challenged the order, my lord. My lord, last order, my lord, 21/2/2025, my lord, wherein, my lord, the evidence
2025.
Evidence has been fixed, my lord. Date for evidence has
File a petition paying for time for evidence. Where is your application? Yes, time was allowed. 3rd of April, it has been fixed.
My lord, what we are sorting from, my lord, 18/9/2024, area amount was paid. Thereafter, they have not taken.
Sir, that was not your application.
But they have
So you paid for time petition only. That was allowed. How can you be agreed by that? By the order impugned.
I have challenged
Your Lordship, I'm appearing on behalf of the petitioners. I'm being led by Ms. Senior Advocate Aniruddha Chatterjee. Your Lordship, in the present civil revision, we have filed it against the order of the learned DRT, which has dismissed our interim application, challenging the order passed under Section 14 by the learned Chief Judicial Magistrate at Calcutta.
There is a provision of appeal. There is a provision of appeal.
Yes, Your Lordship.
So,
Your Lordship, that's why I'm praying for an adjournment so that since I'm being led by Senior Advocate Aniruddha Chatterjee, he can come and apprise Your Lordship of the correct
the prayer of the learned advocate for the petitioner hearing.
Oblige, Your Lordship.
My lord, item number 26, Mr. Shashanko Shekhar, they are paying for petitioner, my lord. My lord, he is suffering for fever, my lord. He is not come to court, my lord. I'm paying for not this week.
On the prayer of the learned advocate for the petitioner. Pass over next. Pass over next. Call the next matter.
For the petitioner.
Yes.
This revision application for directing the trial court to dispose of the misappeal for early misappeal.
Miscellaneous appeal is ready for hearing, Mr. Banerjee.
Miscase.
Miscase. What is the miscase for?
Miscase under Section 4 of the Partition Act.
That is otherwise ready.
Otherwise ready.
This application under Article 227.
Set aside the judgment of trial court and direct it to the trial court to hear the miscase.
Yes.
Against that judgment of the appellate court, opposite parties preferred and has miscellaneous appeal before this honorable court. This honorable court affirmed the judgment of the lower appellate court and directed the trial court to hear the miscase.
So now 15th, 2nd of July was fixed for hearing of the application under application dated 15th of April. This application under Article 227 of the Constitution of India is at the matter?
31 with 32.
At item 31 and 32, I am appearing on behalf of one of the opposite parties. Item 32, my lord, we have not yet been served with a copy of the revision application.
Mr. Mitra, you are for?
Despite having written to them.
I'm for the petitioner, my
Well,
lord.
I am for the ballot again for defendants number 2 and 6, but the copy of my lord this second application has not been served, my lord. As
There
my
are two
junior,
applications, 31 and 32.
yes,
You are for the petitioner in both.
Both, my lord. 31 has been served. 32 has not been served, my lord. Previously, an advocate lodged a caveat that we have served, my lord, but my lord, we will serve again, my lord.
31 and 32, please complete the service.
So, 31 complete, 32 is
31 has been served, I say.
Mr. Medora says that in which matter he has,
He is leading me, my lord.
yes, what is the issue?
the
Amendment.
amendment of plea. Both, both application rejected.
Both application meaning
There are two applications for
for amendment, rightly rejected. Two applications for amendment of one claim, rightly rejected.
Well, kindly takes it up any day, my lord.
This means these two applications right now.
Yes, when this
বলো না আমি ওই আর্টিস্ট্রি আর ইন্টারন্যাশনাল
আচ্ছা নাম করার দরকার নেই
sorry
2
and 6
2 and 6
yes
in both the civil division applications you are 2 and 6
Yes, yes.
should be
Well, the same part.
Mr. Mitchell, learned senior advocate
has been served. The first application for amendment is
because fixing a date that will you want it in the next week.
I would prefer, my lord.
List this matter under the heading motion in the next week.
Gotcha.
21st of July, next week will start.
Tuesday, my lord, 22nd.
Yes.
Gotcha.
Let it appear, Mr. Mitra, if otherwise.
Let's
57.
I appear for the petitioner, my lord.
Party, my lord. I'll be paying for accommodation of only 15
Sir, I am opposing that, my lord. Only on the limited count, the my lordship has 10 fixed matters today. Tomorrow, the contempt is fixed, my lord. Yes.
The notice at 12 p.m. my lord.
No, the matter was mentioned at 10:30 because the your lordship remembers Mr. Shuddha Shatta Banerjee had mentioned it last Thursday also. Well, I'll take 10 minutes. I'll take 10 minutes. You.
Mukherjee, he already had a fixed matter at 2 p.m. in court.
Well, I will take 10 minutes. He can come.
All right. Come at 3 p.m. Yes. Yes.
Item number 103.
My lord, I appear for the opposite party, my lord.
My lord, this is arising out of, my lord, an order passed in an application filed under Order 7, my lord, Rule 11. Though there were other grounds, my lord, in the, my lord, application, but I am really assailing that part of the order where the learned judge has recorded.
The opposite party.
My lord, I appear for the opposite party, my lord.
Yes. My lord, the
My
short
lord, only one submission, my lord, I'd like to make. My lord, no copy of petition, my lord, though there is no caveat, my lord, no copy of petition has been served. If my learned friend can serve a copy and...
He has no right of audience, my lord.
You have not lodged any caveat.
I have not lodged a caveat, my lord. I have to be candid, my lord. I didn't.
My lord,
But my lord, I am raising a preliminary objection, my lord, of its maintainability, my lord.
Suit for recovery of, my lord, arrear, my lord, license fee or arrear rent. My lord, amended plaint cause of action is, my lord, pleaded is 31st January 16, suit filed in 2022. Whether, my lord, learned judge refuses only on the ground that evidence is required to be taken, and therefore only three lines, my lord, kindly sees paragraph 17 of the impugned order. Paragraph 18. Internal
plaint. Show me the plaint.
My lord, first lordship sees the original plaint,
yes,
which starts at, my lord, page 41. The type copies are just the next pages, my lord. So 41. 3 paragraphs which I feel, my lord, would be important. Para 5, which is 42A, refers to the agreement of, my lord, February 2015. Then, my lord, kindly comes to 43 capital A, paragraph 10.
Oh, type copy is the next page.
Yes, my lord. 43 capital A, my lord, kindly sees paragraph 10. Terms of tenancy they have pleaded. It was basically a 11-month license according to the plaint case. Then paragraph 12. Ever since taking possession of the suit property on 17th February, defendant not paid a single farthing towards license fee. This is his case. My lord, the cause of action, lordship kindly comes to, my lord, page 45 capital A.
No, this is the suit for eviction. No.
No. My lord, eviction suit pending before, my lord.
For recovery of the outstanding dues.
It was mean profit. Without, my lord, there being a decree for eviction. This was the nature of the suit.
Recovery of such and such mean profits. And recovery was, what is this amount of? 3 crores?
3 crores, my lord, is mean profit. The outstanding license fee. Outstanding license fee.
Outstanding license fees.
Yes. And mean profit 92 lakhs. That's his plaint case. Originally.
Yes, yes.
My lord kindly takes note of 5 paragraphs, 22 to 26. This would be important. And please take note of the date at para 24, the cause of action.
Paragraph
24. This was there in the original plaint. Then, my lord, 46A lordship will find the
cause of action 31st of December 2020.
That is there, my lord, in the original plaint. Now, kindly takes note of one fact. They file an application under Order 6, Rule 17 during pendency of hearing of this application. When, my lord, it was already on the verge of completion. Learned judge allows the Order 7, Rule 11, Order 6, Rule 17 application. 22 to 26 deleted.
No.
22 to 26 deleted.
Oh, 20.
Replaced Replace,
26 deleted.
yes, replaced by 3 paragraphs, 22A, 23A and 26A. Kindly comes to 95, page 95.
So you are challenging the amendment also.
No, I am proceeding on the basis because my lord, final order was passed.
That helps you.
Kindly see
Amendment helps you. 26A. No,
page 95. Page
Page-
95, Lordship will find 3 paragraphs which were sought to be incorporated by way of amendment.
yes, plaintiff is entitled.
22A, Lordship sees outstanding license fees on and from March 15. Next para is very important. 23A, cause of action arose on 31st January 2016.
And continues till date.
Article 52.
Yes.
Article 52, my lord. 31st January 16, my lord, the cutoff date would be, my lord, 3 years and it would end, my lord, 30th of January 2019.
No, this is claiming license fees till date, saying that you are in occupation without paying. Maybe some part is barred, other part remains.
My lord, major part, as per the plaintiff
Maybe,
case,
but some part remains.
I understand my difficulty. Bifurcation is not possible. Partial rejection is not possible.
Yes. So the if entirety is not time barred, it may be that beyond 3 years they cannot claim.
No, but I am on a different point. I knew this would be, my lord, my obstacle. I am on a different point. My lord, if his cause of action is, my lord, as per plaintiff pleaded case is 31st January 16, then, my lord, he ought to have instituted the suit because we know under 52.
It's a continuous cause of action, Mr. Dutt. It's a continuous cause of action from 2016 till date. So whether he is entitled to from 2016 or when the suit was filed.
22, December 22.
So from 2019, that has to be decided. He may be, they are not entitled to prior to 2019.
To cut the long story short, may I say this? Kindly, my lord, this now has been transferred because they filed it before the commercial court. It's now transferred. They have taken back the plaint. They are not aggrieved by the order. They have again represented it before the, my lord, district judiciary.
No, I could not follow this. This
My lord,
was commercial
this
court.
was being heard before the Asansol commercial court.
Yes, now they have taken back.
Yes,
Rule 10.
In excess, because it was not a commercial dispute. Therefore, the learned judge said it has to be presented before the district judiciary.
So
they have taken it, represented it, and they have acted in terms of the order.
Yes.
Now it's being heard. It has to be tried before the district judiciary. I am only praying for this because, my lord, on the face of it, a part of it is barred. Kindly provide this. Let this issue be treated as a preliminary issue under Order 14.
So, Doctor, it's difficult. Preliminary
My lord, on the face of it, Lordship will see that this is barred claim.
Because part
is barred.
What refusal? All these are this.
No, preliminary issue after trial. The preliminary issue.
Mr. Doctor, preliminary issue, what will be done? Now, if part is there, part we will be getting, that will be the ultimate decree. Segregating that part may be a difficulty in the midst. Because that will be the decree. If according to you, when the court holds that yes, prior to 2019 it's barred, then after 2019 he will be entitled to. So that's the ultimate decree.
No, after 2019 he may be, his claim may not be barred. Whether he would be entitled to a decree is an altogether different question.
Nothing. So if you are entitled to, you file an application, court will consider that.
Unless Lordships Lordships understand it doesn't happen like that anymore.
It's difficult, Mr. Doctor. So better not to press that prayer here because you may have another round of litigation.
I hope to get one sentence, my lord, which would help me.
That observation maybe, I do not know which way it will go.
Prima facie, my lord, Lordship sees. Prima facie. There is nothing in the, my lord, plaint which can, my lord, save this part of the claim, 16 to 19.
So if the
and
plaint,
they refer to
Mr. Doctor, if the plaint cannot be rejected, you know, plaint cannot be rejected in part. So if it cannot be rejected in part, it has to be decided. That's also it's a settled proposition, reiterated very recently.
I'll not waste time. Passes and
this application under Article 227 Going back,
And there is a eviction suit pending where there is a claim for mean profit already there.
6 of 2024. First a para.
Second case, whether the suit is barred is to be decided after taking evidence.
Rightly, in a way, not in so many words, but in effect it is. Where is your application under Order 7, Rule 11 with regard to this?
Well, that application is page 67, whole application 28.
Page 28.
But this plea of limitation was not there originally. Because he was allowed to amend, learned judge allows me to file a supplementary taking additional grounds.
Where is that?
So that supplementary affidavit is at 117.
There the point of limitation was taken. Yes. Which paragraph?
My lord, that will be paragraph 4 onwards, my lord. Lordship may straight away come to my lord
On
paragraph.
commercial dispute, that is not taken care of.
That is now taken care of. My lord comes to paragraph 12. Paragraph 12. 12 and 16.
No, 11 is the effective paragraph. Because 12 you said barred by limitation.
Yes.
11 I think is the effective paragraph.
Yes, 11 is also there.
And 16 you said.
And 16. Because they wanted to, my lord, explain it by showing that there was a reference which they sought to initiate. It was an unilateral appointment. It was a void appointment. So that will not give them the benefit of section 14. We wanted to, my lord, highlight this part in one of the paragraphs.
I think
These are tribal. These are
11
tribal.
is the
Yes.
by the order impugned. Full stop. Has to be considered.
One line.
Has to be considered. That is why I have indicated it cannot be decided at this stage. Trial on
In a
it.
different way, in a positive way, my lord, if it is there, my lord, kindly, my lord.
Above observations, your number such and such. পড়ে না? Dr. please ask
Grateful,
him
my lords.
what to give him a
Yes,
copy.
yes.
Otherwise, he'll be in difficulty.
No, no, we'll do. And I have Mr.
We-
Jain's number. We'll
He will be in
definitely.
difficulty in other way.
No, no, I will.
Deeply obliged, Lordships.
Yes.
Number 140.
Yes.
140, my lord, this is my application, my lord. The order, challenge the order passed in respect of the application under section 12 and 25 of the Guardians and the Wards Act.
Who are you?
I'm the mother.
Father?
Yes.
Yes.
My lord, let me exercise my right to visit to my child. I'm the father. Order that has been, my lord, assent before lordship is an order by which, my lord, only my right to visit my child for 2 hours was, my lord, passed. Actually, evidence. My lord.
Yes.
Yes, my lord. May I submit one thing, my lord? It is the admitted position that the father is the legal guardian. And why I am disputing the right guaranteed to the father to visit my child, my lord. Well, the sole consideration is the welfare of the child, my lord. Well, if we see the conduct of the father, my lord, the claiming is right, my lord. The father has never complied with his right. Even
what right he has not complied?
My lord, he has never taken care of the child. Only to the right to see, a right to visit. That doesn't mean that he has complied the right as a father.
Are you denying the right?
Mental health of the child is also.
What is the mental health?
Mental health, my lord. It is otherwise. After the visitations of the father, the child is annoyed, my lord.
Why? That is because of you.
No.
You are trying to make the child annoyed.
There is not injected anything.
Mr. Chatterjee, this should not be done.
Injected anything.
Mr. Chatterjee, mother has to have an access to the child. It's for 2 hours. Nothing.
Well, at
Please
least,
comply with that.
At least, my lord, the consent
It's
of
for the welfare of the child I am taking.
Yes, my lord.
You are saying welfare of the child.
Welfare is concerned.
Yes. Welfare is concerned. Father has to meet the child. This is for development of the child.
Now, my lord, the
Mr.
child
Chatterjee,
is
don't
growing
say that
with
the
mother very smoothly. It is child is growing with her mother is a very smooth.
Yes, yes, custody, Mr. Chatterjee.
Very well with his
Custody remains.
so far as the education
Custody
and other
remains with the mother. Father.
well,
Yes.
it should be restricted.
Saturday on Sunday, once in a week. Yes.
Well, it should be restricted, my lord.
What restriction?
Restriction. Well, kindly.
Half hour. 30 minutes.
No.
This application. Yes. Sir. Thank you. Ask the mother to impress upon the child the role and the importance of the father in the life of a child. That will solve entire problem. No annoyance after this. Yes.
Item number 244.
আচ্ছা ওইখানে না একটা
I am opposing this application.
Yes.
I am the plaintiff in the court below.
এটা আগেরটা কিন্তু আগের যে ম্যাটারটা অর্ডার হলো সেইটা Yes. Yes.
I am the plaintiff in the court below. I filed one amendment application under Order 6 Rule 17 that some plot number, LR plot number was omitted. Kindly include that plot number in the plain schedule.
What is the suit for?
Suit for declaration. I am claiming the title over the property. They are
Show me the plaint.
Plaint. A plaint will be available, my lord.
Page 9.
Page 9 of this application. My lord, relevant paragraph I am referring to that the page number paragraph number 4 onwards.
So suit plot is
two suit plots.
My lord, I am just
plot number 637 and 643.
my lord.
Lordship.
And now where is the amendment application?
Amendment application, kindly see. They have filed written statement.
Yes, show me the amendment
Yes,
application.
I'm coming to that. Page number 23 is the amendment application. Kindly see the amendment, what is for in the code below. My lord, page number 23, last paragraph, in the bottom portion, in line 7 of para 9 of the original plan, it is specifically added LR plot number so and so, pertaining to the LR Khotia number so and so, in Mouja so and so, Paschim Bardhaman, have not been, but the said plots have not been recorded in the R1. What happens? I made this application before filing the suit. What happens? The backdrop.
Give me a minute. Give me a minute. Give me a minute. This is a suit for
Declaration,
not partition.
not partition. I have purchased long back.
Wait, give me a minute.
বসো চুপ করে বসো চুপ করে বসো ডিস্টার্ব করো না বলবে দাদা বসুন
Yes.
My specific government in this plaint, I will first say the paragraph number 5 of the plaint, kindly look into.
Yes.
4-5. What was my right? That the property led by late Madhusudan Roy was divided 8 annas shares in favor of legal heirs and of late Umesh Chandra Roy, and 8 annas shares in favor of legal heirs of the Joy Chandra Roy. Here we have the legal heirs of Umesh Chandra Roy. Thereafter, the defendant's predecessor Narendranath Rai, son of late Joy Chandra Rai. So defendant's title comes from the Joy Chandra Rai. Our title 8 anna and 8 anna. This is the case. Transferred his 6 anna shares out of the total 8 anna shares in favor of the plaintiff's predecessor by dint of a registered deed of Kovala by deed number so and so for the year 1943.
Sir, what is your cause of action for filing the suit?
Yes. When I have
Please kindly come to paragraph 9 of the plaint.
Yes. Kind. Now, the predecessor of the defendant 1 to 6, I am saying, already transferred 2 plots of land, plot number 637 and 643,
in Mouja Amdia, PS Barabuni, District Paschim Bardhaman, in favor of the petitioner predecessor of the plaintiff by way of registered deed of Kobola. Now, this is our stand. The predecessors of the defendant
With regard to two
plots. Just
how do you include the other plots?
the not other plots. The same apartment LR plot number. It is the RS plot number. Plot number. Now I am
RS plot numbers, this bifurcated in LR.
LR.
Where is your that statement?
That should be tried, my lord. And during the
tried. Please show me that you have made
here,
case.
here the case is that before that
Show me that case made out in the amendment.
Kindly give me 1 minute. Thank you.
Yes.
When I have filed the suit, before that, I tried to mutate our names in the record of rights. BLRO rejected that. Rejected that you are not in the possession of the land. No observation regarding the title of the plot. Now, during the pendency of this suit, thereafter I want to clarify the title which my predecessor had, and now we are possessing on the same title. That is to be adjudicated in the instance suit, and the BLRO findings is not relevant. Now, court has rejected the application for amendment, not on that ground, but on the another ground. Kindly see, they have taken it in their objection, but there is no observation on this BLRO's finding, not required even. That is why now kindly see the impugn order. Last paragraph.
Yes.
Now, reverting back to the merit of the instant petition, it has to be averred that though the petition, the plaintiff willing to implicate some LR plots of land in his paragraph now without stating the deed numbers in the instant petition. I have stated the deed number, original deed number 1943, but filed one deed number so and so in 1943 in support of his contention, and it is clearly shows that the plaintiff has knowledge of the same before the commencement of the trial. I do not understand the meaning, what learned judge actually wanted to appreciate, but did not add the said properties at the time of filing the suit or prior to the trial. His main observation is on the point that I have taken in course of the pendency of the suit. Besides that, the plaintiff vehemently failed to establish that in spite of due diligence, the party could not have raised the matter before the commencement of the trial. Here, my case is actually concentrated. Whether an amendment application, good, bad, or merit, if I say that this plot belongs to me and my restricted area of land I have given, 8 annas, originally inherited from one person, we are possessing on 8 annas, they are also possessing on 8 annas. So my area is not crossing the 8 anna limit of the original title owner.
No, by virtue of this deed, how many plots were transferred?
My lord, that is not clearly stated in the petition. But one thing is that, my lord, the court has.
I'm asking you, how many plots were transferred in 1943?
2 plots, 2 RS plots, and whether
could not have been in 1943.
2 RS plots,
not LR plots.
No.
So according to you, those RS plots have been bifurcated into this. When is that case made out?
If it is corresponds to the LR plot, natural color, if the corresponds to the LR plot, the RS plot number.
That case made out?
My lord, that is a, my lord, respectful submission. That, my lord, I am not agitating before this court. Rightly observed that it was better to draft on the application itself in the order 6 rule 17. The lower court who has drafted the petition in a short manner that these are the plots. If it is not coming within that deed, automatically it will not go. Child, that much I need. That if this LR plot number is included and it is otherwise contradictory to the original title deed, we cannot claim any title. But the same is on the other hand, the court did not reject on the whether it is the LR plot corresponds to the original deed or not. Court has said that as the commencement of the trial has been already started.
Trial did not commence.
Just started.
Yes.
PH, it is date for.
The date for
So
which is not commencement of trial, Mr. Mukherjee.
No, the court's observation I am saying.
observation.
Fixing a date for peremptory hearing is not commencement of trial.
Yes, that is so. And before that, at this particular outset, my submission is that everybody knows, your lordship knows very well, even at the time belated stage, if I took a point, and when the trial has not been defendant, did not disclose their defense.
Yes, anything more?
No, it is similar in the evidence stage.
Evidence, but no
What
party
has happened to the evidence?
No party.
What is the stage of evidence?
On 28th August.
Order that is subject matter of challenge is 2024 order, not 2025.
No. But Mr.
Matter is-
Mukherjee,
but at that point
when the
in time-
application was filed, you have to go to that stage.
That stage
So
was
when
not
the application of
the evidence stage.
Evidence what? Only a date fixing of evidence of PW1, that is not commencement.
No,
of
That was.
Nobody.
That was.
No, it is very nascent stage. of the-
commencement of trial as per the proviso.
There are, your
did
lordship
not-
knows, Lord, that
No.
there are, Lord, the
If I short,
two judge, Lord, line of
Mr. Bench
judgment.
has answered the reference, Mr. Mukherjee, on this.
Yes, Lord, that I understand.
After considering all those judgments, so the division bench has answered that reference, what is the stage?
My lord.
So that stage, subject to correction by you, has not reached. So trial did not commence.
But not on the merits, I'll address your
That's
lordship.
the difference.
So this is my only.
On the
Lord,
merit.
your lordship will kindly come to Lord first the amendment. Now, Lord, what was Lord the ambit of the suit? They were trying to Lord take a declaration on Lord in respect of two of the suit properties by way of a first prayer. The second prayer was Lord concerning Lord a appointment under the land loser scheme concerning a particular deed of the year 1943. Now, Lord, your lordship will kindly have
Land loser scheme.
Yes, Lord.
Lord, I have narrated very specifically. I am submitting.
Kindly
I have
to look
stated.
at, Lord,
Where is? Yes, I will come back to you.
Eastern Coalfields
Oh,
is a
prayer
party.
B, prayer B.
Prayer B. Eastern Coalfields is a party here.
I don't know.
Defendant number 7, 8 and 9. Now,
Restraining the defendant number 1 from getting any benefit of employment
that is
from
under the land losers
as the
scheme.
sale
There is
deed
a
is
land-
fictitious.
Yes.
No, there was a sale deed.
Yes, the year 1953. I'll just point out that
May I clarify?
how they are militating against it.
I've heard you.
তুমি বলবে তো বলে না।
Please take your seat. If you want to submit anything more,
After his.
then take your seat. Yes.
I'll not.
Now, my lord, their case is, my lord, the first paragraph, originally the property mentioned in the schedule below was under the name of such and such, divided to 8 owners. All through your lordship will find that, my lord, that the case made out by them was, my lord, concerning the scheduled 2 plots of land. And now your lordship will kindly come to paragraph 8.
Yes. Land loser scheme, Mr. Mukherjee, is for acquisition, not for sale.
Lord, there is a land loser scheme by the Eastern Coalfields.
Yes.
Lord, as your lordship knows, if they buy a property or Lord, a property has been acquired, more than 2 acres, there might be one employment as against 2 acres. Lord, that is
That is not sale. I think that is
No,
acquisition.
even by sale.
That is also the
Lord,
scheme.
The scheme was that they will be mining a particular land for coal. After it has been mined, Lord, it has been rendered useless. It might be, Lord,
No, sale is you are getting consideration, Mr. Mukherjee.
but even that, Lord, I have done a matter pertaining
For
to
that
this.
also employment is there.
The scheme
All right.
says
So their case is that, or the plaintiff's case is that you cannot take benefit of that sale deed for getting employment.
Now, Lord, this is, Lord, this has been, Lord, sold in favor of, Lord, the defendant number 7, the Eastern Coast.
Yes. So their case is that you cannot take benefit of that that sale deed and take employment from
Right.
from
That is
Mr.
the- that is-
Coalfields,
that is
because
not-
according to them it's void and fictitious sale deed.
Yes, right. Now, Lord, paragraph 9, which they are trying to amend, is, Lord, the predecessor of the defendant number 1 to 6 already transferred 2 plots of land, being plot number such and such in Mauja Samcha and such.
That is paragraph
in
9.
favor of the predecessor of the plaintiff
number
by
12.
will of registered
That is
deed of-
paragraph 9.
of the year 1943. So, Lord, here they are trying to add up by amendment of, Lord, the paragraph 9 to incorporate, Lord, the 6, Lord, LR plots without, Lord, mentioning about, Lord, how they have acquired right in respect of the property. By what deed, Lord, that they have, Lord, purchased this property to seek a declaration, the first declaration. The first declaration was touching upon, Lord, the plaintiff's right, title and interest be passed in the suit property.
Mr.
So they
Mukherjee,
are trying to incorporate.
Mr. Mukherjee, only there are two things.
Lord.
1943, there cannot be those 6 LR plots.
No, the 6 LR plots
So
were
whether these 2 RS plots have been bifurcated to those.
nowhere your lordship can impute, Lord, that particular, Lord, that whether it comes from, Lord, those plots or not. Because here, when they approach before the BLLRO negates their claim. They went up before my lord under section 54 before the appellate authority negates their claim. My lord, that is
That
all-
attained finality.
Yes.
with
And
regard to-
thereafter, they have not gone up my lord in appeal. They did not get any relief. Coming back to the suit to include this plot because my lord, they could not satisfy about my lord, the title of acquisition of these 6 plots. That is exactly my written objection, my lord. I have not brought forth. If your lordship have a look at my
Where is
written
that?
objection, page 26. So, my lord, circuitously they are trying to, my lord, achieve which they could not do directly and prove it before the authority concerned. My lord, page 26, your lordship will kindly have a look at, my lord, paragraph 6 onwards. Then, my lord, the narration of what had happened will be the next page, page 27, paragraph 8 onwards. Paragraph 11, where it rests.
Yes.
This was observed by the trial court. Now they come back at, my lord, at the stage when, my lord, the matter is to be heard. With this application, which is, my lord, absolutely a cryptic application, doesn't, my lord, give any particulars to say that these are to be incorporated in paragraph 9. Paragraph 9, my lord, does not talk of anything, my lord, concerning how the derivation of title happened.
No, amendment is in paragraph 9.
Yes.
Or after paragraph 9.
No, my lord, in
Paragraph 9 of the plaint. Of the
page
plaint.
23, in line 7 of para 9 of the original plaint, it is added as LR plot number such and such. There are 6
Paragraph
plots.
20, yes. In
No,
line
page
7,
20, page 23.
it is to be added. Line 7 of paragraph 9.
So what they are trying to do is that
In
not
line
only
7 of the suit property,
in line 7 of para 9.
LR plot number.
ওটার সঙ্গে প্লেন্টের পাতাটা বার করে রাখ।
But they are not amending the schedule.
They are
They're
not
not
amending
amending the
schedule. They are not
What
giving
type of a
particulars.
this application is
Therefore,
it?
this application will obviously, my lord, if they want to succeed on the statement, they have to also give the derivation of title for not the first prayer. This is, my lord, for the purpose only because they have lost in, my lord, incorporating their name in the record of rights. They could not substantiate their title. They are trying to embroil, my lord, this particular properties in the suit at a belated stage.
May I just reply on this
Yes.
point of record of rights? The BLRO's power.
Not a document of title, it's a document of possession.
And
Yes.
every case is that the BLRO when rejects, we can file a title.
Yes, you are for?
I'm for the collegial ballot. I'm supporting the cause of Mr.
So,
Yes, what do you say? It's to be allowed amendment.
No, certainly not.
Not.
No.
Yes.
And if he says yes, it is
Yes.
good. Or it is required a comprehensive trial. Number one, trial is at the very beginning stage. If it is not yet concluded, as per your lordship, it is at the very beginning stage. They can easily, my lord,
Don't rely on the observations of.
So
That was
is
only
why,
to counter
my
Mr.
lord,
Mukherjee.
considering the judgment of the appeals court, I need not to place it before your lordships that a liberal approach is required to be given. My lord, kindly appreciate my point. They will give ample opportunity on my title. They will cross-examine.
This application under Article 227 of the Constitution
Case number 250.
My application.
Yes, Mr. Gupta.
By
Any
the-
caveat? No caveat.
No, my lord, it was no.
Rise opposing.
Yes,
No caveat.
Rajdeep Bhattacharya is with me.
You have been served with a copy.
It's appearing second time. There was
Appearing
direct-
second time.
Firstly, it was entertained. There was stay. I was directed to serve copy, and thereafter it is appearing. By the proposed amendment, an application for amendment of plaint in a matrimonial suit has been refused. The amendment is pre-trial amendment. What I intend to bring on record in the by way of amendment, that after filing the suit for divorce, there was
Who are you?
husband, senior citizen, medical practitioner. The wife was also. My lord, the suit is on the ground of cruelty, and after filing my suit, my lord, there was a proceeding for divorce on mutual consent. Both of us filed a proceeding for mutual consent divorce.
13B.
13B. In that, the wife did not appear despite 3 or 4 directions. The court lost its jurisdiction and it failed. This fact happened after filing of the suit. The purpose of bringing this amendment is only to bring on record the facts taking place during the pendency of suit. Kindly come to, my lord, the order.
Mr. Gupta, how that is relevant?
It's relevant, my lord.
Mr. Gupta, there are two aspects of the matter. One is, the order sheets of. Yes, Mr. Gupta, the divorce, suit for divorce is on certain specified grounds and under section 30. So mutual consent is a different aspect altogether. So how that is necessary?
Mutual consent.
Failure of mutual consent does not give you an additional right of divorce.
No, it is a ground, my lord, in the sense, it is a ground in the sense.
Additional ground for divorce.
My lord, no, it's not additional, it was existing. Kindly.
Existing ground, Mr. Gupta.
No, why that was not allowed? That both of us jointly filed application. I was anticipating on the basis of this joint application, the parties acted upon. Both the parties acted upon the joint compromise.
Where is the amendment? Show me the
I'm
amendment.
coming straight. Kindly come to, and both the parties acted upon this compromise which was filed in that proceeding. Thereafter,
Mr. Rai.
4 dates were fixed.
Mr. Rai.
He abstained from appearing.
If both of you have filed mutual consent, why are you fighting? Wastage of time.
Client, medical practice.
7 years client and the wife is.
Yes.
And can it takes up the call?
No. I've stopped. Why are you, since both of you have filed an application for petition for mutual consent, why are you fighting again?
Opted by fraud and coercion. Page 54. What is the cause of action for filing of the suit? With the divorce suit.
So this 13B was by way of coercion. That is your case.
Yes, I filed an application in the divorce suit because that is
All
why
right.
my lord can it.
Decided.
Yes.
If he says it is by fraud, then it is.
Where is your amendment
Kindly come to that. I am coming, my lord. Kindly come to my amendment application. That is at page 77. Kindly look to the schedule of amendment. It starts from page 77 that your petitioner has categorically stated in the plaint in paragraph 22, 23, 24 that the parties to this suit has previously filed a matrimonial suit 232 of 23 under section 28 of the Special Marriage Act, but the respondent discontinued to appear before the learned district judge for evidence, deposing in that case day after day repeatedly. By negligent attitude, the respondent wife, and after filing the matrimonial suit, the respondent has withdrawn her consent in mat suit number such and such by filing application on 12/4/24 on some false and frivolous ground, and finally the learned district judge at Howrah was pleased to allow the application of the respondent dismissing said suit. The above subsequent event taking is necessary to be incorporated in plain for proper adjudication. The proposed amendment is formal. Kindly come to next page. In page 21, after end of para 24 of the plaint, a new paragraph as 24A may be incorporated in the plaint as hereunder. This is the paragraph. That during pendency of this suit, the respondent filed an application dated 12/4/24 in match suit number, that was mutual divorce proceeding. By that application under 151, the respondent stated that she has been made to sign on mutual divorce application without her consent, and for which she withdrew the consent in match suit number such and such. And finally, the learned district judge was pleased to dismiss the match suit on 12/4/2024. Your petitioner states that the same is contemplated for such application without taking legal action, and this is amounts to cruelty as against the petitioner. Now, my lord, the application, this is the written objection filed by them, page 82. Kindly come to the impugned order. This has been rejected, only observing last at the bottom. Your lordship will find this is a suit filed by the petitioner husband against respondent wife under section 27 of the Special Marriage Act for divorce, stating that the marriage was solemnized as per Special Marriage Act on 29/5/19 on ground of cruelty. I have gone through the judgment relied upon by the learned advocate of the petitioner husband. The fact of the case, the fact and circumstances of the judgment of the Honorable Court relied upon by the learned advocate for the petitioner is totally different to this case in hand, and it has no bearing or applicability in this case. So the proposed amendment as prayed for by the petitioner husband in this case will not help in determining the dispute between the parties. Your lordship knows Rajesh Kumar Agar
Act suit.
Special Marriage Act suit.
Special Marriage Act suit.
They say that the application, according to them, they have not signed it. According to them, they have not. But the benefit which they got, and they abstended after 6 months for 4 dates. And all these
What
dates,
is the benefit that they have got?
I am coming to that. The kindly come to the dates which
Listen.
I will give you lordship may not the date when this was done. I filed the suit, they filed written statement, and just after the written statement was filed, this order was passed. The order your lordship will be getting at page 76. This is the order, because that suit
70
page 76. This order was passed just immediately after filing WS. I can give the dates also, my lord. The date is 26 September 2024. The suit is filed. The WS has been filed in February 24. February 24. This order is passed on 12/4/24.
So that is during the pendency of this suit.
Yes, before commencement of trial or
No, Mr.
pendency of suit. Yes, the suit is filed on 26 September 24. WS is filed on
No, suit is filed in 2023.
22. My lord, I have
No, the
date.
present suit where amendment has been rejected.
26 September 23.
26 September.
26 September 23. WS is filed on February.
26 September 2023 suit filed. And when that mutual consent was filed?
This was on, the date has been quoted in the order, which is, I'm giving that. 12/4/24.
12/4?
76, 12/4/24. On the same date it was filed.
12/4/24.
Page 76.
24, the mutual consent petition was filed.
No. It was withdrawn.
I'm asking you when the mutual consent petition was filed.
It was filed long before. It is 23, long before.
When? Please give me the date. Which one is earlier? The suit.
No. This matrimonial suit of divorce was much anterior.
Yes.
Therefore, in paragraph 23, I have pleaded in my match suit. Kindly come to paragraph page 48. Last paragraph, your lordship will find. It's much anterior. Page 48, last 4 lines, your lordship will find.
Yes.
Last 4 lines, 27 to 23, the petitioner filed an application Your Lordship will get the date.
Page 48.
Page 48 of revisional application. Page 20 of plaint. Internal page 20 of plaint.
20 of plaint, yes.
Yes, last 4-5 lines. Date is 27 February 23. The petitioner, that means plaintiff, filed an application being case number 232 of 23 Howrah playing inter alia for mutual divorce.
Oh, during the pendency of this suit, parties filed an application for mutual consent.
My lord, the mutual consent suit is dated 27 February 23.
So prior to this suit.
Prior to this suit. This suit
And
is,
when that application was pending, this suit was filed.
this suit was filed because 3-4 dates were given. The wife was not appearing. Therefore, we understood that the court will be losing jurisdiction. Therefore, we filed this suit on 26 September 23. This date is 27 February 23. This is mutual divorce. And contested divorce is 26 September 23.
Mr. Gupta, when the first date was filed after filing in the mutual consent?
First date?
Yes. In the mutual consent?
On 27 February 23.
27th you filed. So thereafter the parties have to appear after 6 months. What is that date?
August 23. August I have been told. I may remember.
And after August, what happened?
After August, 4 occasions court granted them time.
That is after. Prior to that, you have filed a suit.
File the suit. No,
So
not
prior to that, you.
no, I'm extremely sorry. After when 6 months came, I'm sorry, kindly excuse me. After I waited for 6 months, did not file the suit. The court fixed that I am giving an opportunity so that wife can come.
What is that opportunity being granted? What is that date?
Date, your lordship wants. 6 মাসের পরে ডেটটা কত ছিল?
4 September.
4 September.
15 September.
Miller, my client since he's here because I could not remember. 4 September and 11 September.
Yes.
Because my 4 September, these 2 occasions, I waited eagerly that had the wife appeared after this twice or thrice direction, this proceeding could have ended. But she allowed the court not to pass the order because she didn't appear. Thereafter, 3 dates were fixed. On all 3, she did not appear. Thereafter, she filed an application on the 4th day in the mutual consent, stating that she is not ready to give consent. And this was 12/4/24. On same date, the court said, I am allowing that application and I don't have jurisdiction. I have annexed the order itself. That order has been, I have shown you.
Where is that application filed in that mutual consent petition?
I was given in, I can bring it up. I can bring, so my lord.
Yes.
Now, my lord, the fact, the dates which comes in, I have shown to your lordship.
Mr. Gupta, how that proposed amendment is relevant for the purpose of deciding a suit for divorce?
And I kindly appreciate, my lord, when both parties file an application, the court gets jurisdiction to pass an order. It is on the basis of this mutual affidavit application, the court gets jurisdiction to pass an order. Now, there is a consent recorded in respect of the terms to which both of them are signatories. After, my lord, she allowed me to wait for 6 months. I waited there. I was hopeful that she will come and it would be allowed. I waited for further 2 direct dates. When I find that on all 3 dates she is abstaining from, I understood that her motive is not at all correct according to me. Now, on the 4th date after filing this WS, kindly take note.
What is the ground in the suit?
My lord, I am coming. The WS has been filed in.
What is the ground in the suit?
The ground is, my lord, the main ground, Lord, I am aware of that. Because the main ground of divorce is that my client, who is a senior citizen, about 65 years old, have retired now. He all along since last 50 years has been residing in Howrah. The wife is insisting now because the marriage is in 2019. It was only 1 year marriage. The wife is insisting that I should stay with the wife at Lake Garden in Kolkata. And my client is not interested to leave his place at Howrah, Belgachia, because he has a chamber in Belgachia for last 40 years.
So that is the ground for divorce.
Ground for divorce is that wife is not giving company to this husband at Howrah, rather forcing my client that you stay, if you want to stay with me, you leave that and sell out this property at Howrah and come to me at Lake Garden. How can I go to Calcutta, my lord, when I am a resident of Howrah for last 60 years? I got birth there, my families are there.
Everything, but how this proposed amendment is relevant for the purpose? Because
This is,
there are,
the wife is perpetrating a cruelty that I should stay according to her wishes.
that is, Mr. Gupta, that is already there in your plaint. That is the ground in the plaint. The proposed amendment, how that is necessary for the purpose of deciding the suit.
Compromise, he said that yes, as you do not want to come here, as you do not want to come at Lake Garden and stay here, I am not going to live with you. So let us quit and dissolve the marriage. I agreed. It records consent on the part of the wife that she will not come to Belgo, our Howrah. And she is rather.
So, Mr. Gupta, that is the ground for failure of 13B, or that is 27.
I am now concerned with the failure of 13B. It is a cruelty, my lord, playing with me all time. How can, my lord, I kindly consider the difficulty on my part. I being a husband, I informed.
Anything more, Mr. Gupta? Anything more?
I, my lord, informed her because I could not marry because of, my lord, my son was at the PG hospital at that point of time. It is through me the son was born and brought up. He was given marriage, now he is established doctor.
Yes, Mr. Rai.
Once he became a doctor, I thought that now I should settle. For the moment I thought that I should settle, she said, yes, I will go and live there. I felt ill for my knee.
Now you are also interested in settling. Are you interested in settling?
My lord, if she is ready to stay and give an undertaking that she will stay with me at Howrah and not force me to live with her at Kolkata, I am ready. But on 65 years, even at this stage, I will not be having a wife who will be staying with me.
Mr. Rai.
I have spent all my days in education.
All right, yes.
Being a doctor. Now,
Any scope of settlement? He says there is
That I have to take instruction.
kindly consider
one thing, my lord.
predicament of the husband.
Yes.
Whether the parallel proceedings over the matrimonial suit can be continued, if you are logically considered that way.
Mr. Rai, that is
That point. Application of final relief.
no, but Mr. Rai, that has ended. So that has ended. One proceeding has ended. Whether that could have been continued or not, I cannot go into that. Now only one thing.
Next, my lord, can you turn to paragraph 30?
13.
30, page 54.
Page 54.
Yes.
No, what is page 54?
Yes.
This is your written statement.
No, this is a copy.
No, what is this?
It's written statement.
Page 54 is written statement.
Yes, it's written statement.
Yes, 54, you also got it.
Yes. No, 54 is not the written statement.
It is the application.
It is pleadings of written statement. It's pleadings of
written statement.
Page 54, para 30. If your
Yes.
worship is looking at.
It is the copy of the application.
It's WSC.
WS?
It starts from.
No, it is the plain.
What
Oh,
will
I'm sorry. Extremely sorry. No, it's a plain, sir. Plain, I'm sorry.
Page 54.
Sorry. I'm sorry. I stand corrected.
Yes.
I'm sorry.
Page 54, yes.
Paragraph 30.
From 61. His
Yes.
written statement starts from 61.
Yes.
So this is the
This is the original plaint.
This is the original plaint. After that, B last 1, 2, 3, 4, 5 lines from the bottom of page 54.
So this averment is already there.
I could understand.
No, the averment is relating to filing of suit and affidavit. But this plaintiff is dated 26
Yes,
September.
Mr. Gupta, I will come back to you. Yes.
This is subsequent
Yes.
taking place, my lord.
Now, man, can you turn to after that? Paragraph 33.
Yes.
The petition all times, my lord, may I read out paragraph 33.
Yes.
The respondent will change will change her decision or change her conduct to cruel attitude, but the respondent did not change her attitude finally, and since deserted the petitioner willfully neglected him, and so he is guilty of a cruel attitude and married life of your petitioner was his most unhappy and unfortunate one. And the respondent have behaved with the petitioner very roughly and with the such and such manner. I am skipping over. The respondent failed to appear. My lord, got it. Just before the judge, how
This is paragraph 33.
Yes, yes, yes.
I'm at paragraph 33, last portion of paragraph 33 at page 57. I have read
yes.
that. Yes, next.
Has no other alternative but to withdraw his consent.
Yes. I have read up to that. Anything more? Anything more?
So, what is the? I put this. It is already there.
Application under Article 220.
And the court is of the opinion, Manor Kali. Before that, Manor Kali record that the initiation of this proceedings due to the pendency of Section 29.
Application under Article.
Your Lordship knows that merits of the matter cannot be gone into at that stage. They say that this is fraudulent or not. 16, 17, your Lordship have cited in all cases. Kindly have it. This is your
What I have
Lordship knows.
cited.
Paragraph 16, 17, your Lordship may kindly recollect it. Rajesh Kumar Agarwala. That
17.
Yes.
For what proposition?
That they say that the application they have filed may not, they have allowed it because they do not agree with that, and it is fraudulent. If they say that the application containing their signature and all terms are fraudulent, this gives to an issue to be decided. Because
This application under Article 227 of the.
that he will, and one thing, your Lordship will be passing one. Kindly excuse me for this. Since my client is here and it falls on your Lordship, if my learned friend's client is ready to go there because age is 65-6, if they can,
Mr. Rai can impress his client to go there.
See, it is
Mr. Rai who has to take
I
responsibility.
do not know whether they will agree or not, but once if he can try.
Mr. Gupta, that can be done.
Condition,
Mr. Gupta, that also can be done after this order is passed. Yes, this application under Article.
If this is disposed of, then it will never be possible.
It
It is for your Lordship. I am not insisting your Lordship for that. But one thing, if Mr. I can take that is his client, it will end the litigation for all purposes. On any condition, my client is ready, my lord. At this stage, if you
Mr. Gupta, don't strain your voice.
I'm extremely sorry.
At this age,
It is
you have
all-
the microphone. You have
If your
to the
Lordship may
microphone now.
kindly,
Why are you straining your voice?
if it will end the dispute, because one day, if your Lordship may, I do not know, my lord, whether she will agree or not, but it can end considering the age of the client, 65, and he is now retired from the hospital. If Lordship may keep it, you know, the parties will fight, but if they can take it that in this
Because
way,
they are
it is
allowed to
it ends the problem. I am extremely sorry, my lord, kindly. Considering the age,
I asked you.
It's only considering the age of the
entire wastage of half an hour.
Kindly excuse me. Sometimes we are compelled because of the age.
Yes, Mr. Rai, any possibility or no?
My advocate is today. I do not find him, my lord.
Ask him if it is take instruction. Otherwise,
4:30, my lord. At 4:30, your lord.
Yes.
Tomorrow.
4:25. Assistant Secretary is here, not after 4:30.
4:29, my lord will come.
Yes.
Your lordship will be disposing, but if it can end the problem.
Yes, comment.
Interesting, my advocate record show that something can be.
They can also take instruction if it is not possible. In
Yes. What is the next one? Interest one. The fixed column set it up. Yes.
3 p.m. to
Item number 57.
My application.
Yes.
57 na?
57 was taken up
3 p.m.
because a busy council has to be accommodated.
No, আমি আমার ওই বাড়ি চলে যাবো দাঁড়াও বসো এখন আগে
No, the contempt is tomorrow. That's why the.
কতক্ষণ চালাবো
Yes, sir. Contempt is tomorrow, he says.
He should be held in contempt. My lord, kindly.
Then
have a
I'll
look at the
then-
orders, my lord. I'll tell your lordship.
No, then
I
I'll
have
place my
prepared
case.
I have prepared a list of dates to
But
just
I'll just
indicate.
place my case.
So can you wait till tomorrow so that I can be taking up tomorrow?
Tomorrow I have some personal difficulty. I'm not in town, my lord. May it be on Thursday.
Then don't proceed with that
No,
application.
I'm not proceeding. I'll not proceed with that application.
Mr.
So the only
Banerjee,
thing
that's
that I want
apprehension,
today,
so I'm keeping it.
the only thing I
Then
want
that's
today-
fine, my lord. If he
Just
doesn't,
respect, my lord,
if
let
he
me
doesn't-
comply with the order.
no, my lord,
But
that,
I endeavor to
my lord, that
file
let
the
him not hijack
application.
my case. I'll have my turn.
Well, let him
If
place his
we're
case, my lord,
venturing
I
out
can
of
argue.
turn, we can come back on Thursday. If he assures your lordship we will not press the contempt tomorrow, then we can come back on Thursday, my lord. We've also disturbed your lordship's business.
That I will not. Once the matter is
Then
done,
that is
then
fine.
fixes it on Thursday.
I'm not
Yes.
recording anything. Please do not.
No. My lord, your lordship knows, my lord. Once it is spelled in open court, my lord, it will not be. Well, we'll simplicity take an adjournment that the matter is adjourned till Thursday before the honorable court. That's it, my lord. But let it be fixed on a particular time, my lord.
Yes,
Because
whenever that's
I have
convenient.
father-
As jointly prayed by the learned advocates for the this matter, the hearing of this matter could not be concluded due to paucity of time, as suggested by the learned advocates for the respective parties. List this matter Thursday date দিয়ে দিন, Thursday or 21st of July. Mr. Banerjee?
No,
20%. It will not come out of
that one day your lordship will not keep.
Friday করে দিন, Friday at 2 p.m. করে দাও.
Grateful.
Very grateful.
Yes.
And নাম দিয়ে দিচ্ছি। খুশি?
No.
Mr. Chatterjee was saying that will it be in 2 minutes or 5 minutes? I'll say 2 minutes.
Yes. Yeah.
Item number 27.
My lord, I'm for the petition, my lord. Lord, this is the husband's application, my lord. I'm suffering in my lord.
এটা এটাই combined mistake.
My lord, this is a husband's application, my lord. Challenging the order of my lord. Interim maintenance passed, my lord, under the Special Marriage Act, my lord. 52,000, my lord. 10,000 I'm already paying, my lord, under domestic violence proceeding, my lord. My lord, there is.
So you are here.
My lord, your lordship, it fell
Lord,
from
in
your
the-
lordship on the last
What
occasion.
happened? Forgot.
It fell from your lordship, and my learned friend was to impress upon his client whether there can be a settlement with regard to a quantum. Your lordship's desire was that if he pays a lump sum, your lordship would be staying this order and remanding the matter back to the court
yes.
on trial on evidence.
Yes.
My lord, my client, my lord, both my client and my learned friend's clients, my lord, are here, my lord. My lord, what I'm submitting, my lord, my clients, he is a 38 years old, my lord, and the wife is, my lord, 37 years old plus. My lord, the marriage was, the couple stayed together, my lord, for 2 months only, my lord.
Merits I will hear you after. What's
No, my lord, I'm not making any submissions on merit, my lord. I'm only one thing, my lord, I stated, my lord, my junior, my lord, had talked to the other side's advocate also, my lord. There is a scope of, my lord, one-time alimony settlement, my lord. I have offered 14 lakhs, my lord. My learned friend's client expecting 20 lakhs, my lord. If, my lord, it can be resolved, my lord, since there are early ages, my lord, it can be resolved, my lord.
So that is the permanent alimony.
Yes, my lord. Yes, lord. My client, my lord, is a.
Area is more than 22.
My lord, my client, my lord, no, my lord. As per the order, my lord, this order is completely
Understand? You said permanent alimony 14 lakhs.
Yes.
He said permanent alimony 20 lakhs.
20 lakhs.
No,
that
not
is-
permanent. I am.
He is not saying permanent. That is the difficulty.
No.
परमानेंट ही तो बोल रहे हैं ना सर अपनी तो बोल रहे हैं
Permanent, my lord. Settlement, my lord.
सेटलमेंट अमाउंट
I was then under the wrong impression. I had a talk with regard to this 22 odd is the
My lord,
area.
His submission was that with regard to that lump sum.
not lump sum is the permanent element
No,
That is I thought. That is why I am telling
no,
you.
my lord. My lord, there was an earlier attempt also.
Yes,
in trial court.
Let me decide on merits.
Then,
Yes.
my lord, kindly take out the application, my lord.
Yes.
My lord, the section 36 application filed by the wife, my lord, it is appearing, my lord. kindly come to the application. It is annexed at koto number pata hai? Yes.
139.
139, my lord. 139, my lord, is the application annexed.
Yes.
My lord, kindly come to paragraph. My lord, kindly come to paragraph 3,
না না এটাই বলছি
page 140, my lord. My lord, here the petitioner, my lord, stated, my lord, that my earning is, my lord, 50,000 rupees per month. My lord, kindly see the second line. My lord, the order was passed, my lord, 50,000 plus 2,000, my lord. There is no evidence to show that my earning is that much, my lord. I'm a struggler, my lord. I was working at the time of marriage as a in a bank as an assistant manager, but my lord, I resigned. And I'm a struggler, my lord, pursuing my career in, my lord,
movies.
Movies, my lord. Let my learned friend show that what movie I have directed,
Mr.
or
Mr.
what
Doctor, please take your
under which movie I have worked with. Let him show one example.
All right, all right. Yes, yes. Don't be swayed by his side comments. Yes.
Yes, my lord.
Yes.
My lord, as a matter of fact, my lord, I have talked to my client. His financial constitution, my lord, is not.
No, that is
So
your
that will, my
internal.
lord,
That
my
is
lord,
your
what-
internal communication. I do not want to know. Please from the facts.
My lord,
Materials,
I have,
please show me.
my lord, my lord, my humble submission, my lord, the impugn order. Kindly look at the impugn order. 144. My lord, it's a purely mechanical order, my lord, without considering. Your lordship has seen in the application, it was only ever meant 50,000 rupees per month. And my lord,
Where is your affidavit of assets and liabilities?
my lord, I have not filed, my lord. This is an ex parte order, my lord. Yes, I got an opportunity, but my lord, there was a talk of settlement, my lord. I did not file.
You have got an opportunity but did not file. So an adverse inference has to be drawn.
My lord,
for that.
I have pleaded, my lord. There was a talk of settlement, my lord. I was trying to get the matter settled, my lord, but it was not materialized. That's why
application was.
Dana bhai bolchi. That is why, my lord, I did not file the. I was expecting matter to be settled. There was a talk of settlement. Even matter was mediation. Mediation was failed, my lord. I did not. I could not, my lord. This is the facts, my lord. Reality. In this before your lordship, my lord, I have disclosed my IT returns, all documents, my lord. My lord, I don't earn that much, my lord. I don't earn that much, my lord. And my lord, there is no evidence placed by the wife, my lord, before the learned trial court, my lord, disclosing that I earn that much.
How can the wife say so? It's your personal knowledge. It's you who have to discharge your burden. For that, you are required to file the affidavit of assets and liabilities.
Yes, my lord.
If you have
Yes.
chosen not to file, adverse inference has to be drawn for that.
But my lord, but the judgment, my lord, is contrary to the averments made in the petition, my lord.
Has
My
to
lord,
be
kindly
what has drawn an adverse inference because there is some allegation. You have disputed that, but you do not have any documents to produce. It's you who have to prove your income, and you have not produced any document with regard to that.
क्या 3rd July?
एफिडेविट नीचे कोर्ट में फाइल हुआ है 3rd जुलाई को.
I have filed it.
I have filed.
My lord, I am told, my lord, on 3rd July, which year?
This year, 3rd July.
My lord, after this order, no, in execution proceeding, my lord, I have filed, my lord. They have initiated a execution proceeding, my lord, in pursuant to the.
I did the execution proceedings. There you say,
My lord, there, my lord, I have disclosed the affidavit, my lord. What I am seeking today, my lord, if the one-time alimony issue is not settled, my lord, amicably, my lord, then, my lord, kindly.
Sir, one time permanent, if he is not agreeable, is one thing. If last occasion your submission was that, you have to be given some opportunity to file that.
My lord, I have
can
taken
give that subject to if you pay some lump sum amount. If you do not pay that, I will proceed with the matter in accordance with law.
My lord, I have taken instruction, my lord. My lord, my client, my lord, at this moment, my lord, will be able to deposit, my lord, 50,000 rupees, my lord.
50,000 is nothing because your per month alimony is 50,000. per month alimony which has been, and till now, how much amount is due?
Around 24.
20?
lakhs. 24 lakhs.
My lord, this order, my lord, will not survive, my lord. If my lord,
Execution execution will fail.
my lord, kindly
Execution
appreciate,
will fail. If you do not have anything, execution will fail.
my lord, kindly consider my position, my lord. My lord, I'm struggling, my lord. I'm struggling. And my lord, I'm already paying, my lord, 10,000, my lord, diligently every month, my lord, in terms of the maintenance order passed, my lord, under
That
the
will be
domestic
adjusted.
violence, my lord. My lord, that was
That
not,
will be
my
adjusted.
lord, the wife,
That is
my
not
lord, the
adjusted.
wife, my lord, did not disclose that factum also, my lord.
All right, that will be adjusted with the
My lord,
quantum.
I
Has to be adjusted. I think Mr. Datta will also not
my lord,
dispute that
my lord,
proposition.
my lord, I cannot afford, my lord, 50,000 rupees, my lord. My lord,
That 10,000 has not been adjusted with this.
no.
This was a
And I'm
subsequent order.
and I'm
It was
paying.
probably a subsequent.
Maybe if it is a subsequent
Yes.
order, Mr. Datta, you cannot
Yes,
get
yes.
both.
Yes.
You cannot get
Domestic
both.
violence order was passed earlier, my lord. I have
2017.
There are a
in
person,
2017, my lord, this order was passed, my lord, under domestic violence proceeding, my lord. My lord, I have annexed those orders.
Yes, yes. I think Mr. Datta will also not dispute.
Yes.
10,000 is the amount. He is not disputing that.
I am
a person, well, there are two aspects. One is settlement and the other is merits. A person who travels abroad every now and then,
and my lord,
pursues his
my lord,
career
it is also
is-
not a case, my lord,
My
that the wife, my lord,
We can
is
disclose
not
the
doing
passport
anything, my
from
lord. Wife,
Prove
my
that.
lord,
Have you proved that?
yes, my lord.
Show me.
and I can
Supplementary
put it on
affidavit of-
affidavit that because of
My lord,
their
she,
actions, I was removed from the job.
my lord,
I was removed from the job.
she is working, my
On
lord,
the
in
job,
this-
you are working.
I was working at the time when I filed the application.
Yes.
I was working, as they had mentioned, in DPS Newtown. But
Yes.
because of their actions, I was removed from the job. From 2020, I'm out of job.
अरे भाई उसमें तो- my lord,
For the last 5 years, I have been
my
out
lord,
of job.
till date, my lord, I have paid, my lord, more than 3.5 lakhs, my lord, to the
This
wife, my lord.
application under Article 227 of
My lord,
Sir, why a person quits the job of an officer of a
my
bank?
lord, kindly appreciate, my lord.
earned 40,000 in
Suppose,
that.
my lord, I got an opportunity
Yes.
of a judicial officer and I resigned and I joined practice, my lord. Your lordship understand, my lord, being a struggler, being a initial days of advocate, my lord, that much amount cannot earn by a lawyer. The similar, my lord, things
Who
happen to
says?
my client, my lord.
Who says?
Yes, my lord, this is a
I
fact,
think
my
Mr.
lord.
Datta will not agree to that.
Your lordship, initial first 10 years,
All
my
right,
lord,
yes,
we
call the
don't
next
earn
matter.
that.
This modification will be with effect from the date of the order.
Monthly certain number 84.
This modification will be
Why?
Retrospective. Retrospective.
My lord, kindly consider, my lord. May I, my lord, his financial condition.
no.
His
We
financial,
are absolutely in
my
area.
lord, his financial condition.
The order impure stands modified only to the extent as indicated.
My lord, his financial condition, my lord, is not that much, my lord. Kindly consider
sir.
that.
Yes, I am in the next matter now. Yes. Yes.
Lordship, item number 310, it was a 2 p.m. fixed matter. Lordship, the matter is pending on 16.
Matter is pending what?
Pending before the learned trial court on 16, that's day before.
Yes, please wait. Yes. Who is in 94? Please wait, madam. Yes.
In today's list, 2007.
Item number 84 ta ki monthly
310.
310 টা একটু মার্ক করে রাখুন। তা আজকে ফিক্সড আছে?
আজকে 2 p.m.
হ্যাঁ, এটা মার্ক করে রাখুন দেখছি। Yes, yes.
My lord, the difficulties, my lord. My lord, some other matters were fixed as 2 p.m. in the daily list, my lord.
Yes.
Mr. Roy, my lord, has with the perception, my lord, that the monthly list would be called after.
Yes, please start.
My lord, this matter, my lord, has to be moved by my senior, my lord, my lord.
Yes.
Well, my plaint has been, my lord, directed to be, my lord, a return of plaint, my lord, has been directed upon an application under section 11 of the Suit Valuation Act. My lord, read with, my lord, the 7(5) of the West Bengal Court Fees Act.
Yes.
My lord, in a suit for eviction, my lord, it has been valued at 200 by me. The other side has been, my lord, and
How can you value it at 200?
that
Suit
part,
for eviction?
my lord, this part, my lord, let my senior. My lord, kindly, my lord.
Then it will go back.
My lord, my lord,
It will go back or you proceed.
my lord gives me a short password. My lord, the difficulties, my lord, it's mentioned, my lord, in such a manner, my lord.
Why? From 3 p.m. I've said 2 p.m. That is why I've stopped those matters. That is why I've stopped those matters.
Short password. My lord. I apologize, my lord.
Yes, call the next matter.
Item number 254.
Your Lordship, I am for the petitioner. The issue is that the petitioner is a plaintiff in a preemption case which has been filed in 2018. Now, on the date of the examination in chief, the petitioner was unable to come to the court, my lord, and in the next occasion, a show cause was given. He was unable to attend, my lord. The matter was dismissed for default, my lord. Now, in the restoration application was filed next to it. In the restoration application, the petitioner failed to.
Where is the order passed in the suit?
My lord, the order passed in the suit is, my lord, my lord, page 29.
Who are you? Preemptor or preemptee? Oh, suit was dismissed for default.
Yes, my lord. The suit was dismissed for default.
Where is your application for preemption?
My application for preemption is, my lord, at page, my lord, 19. 16, my lord. My lord, he was ill, my lord. He was unable to come to the court, my lord. Now, the restoration application was filed, my lord. In the restoration application, the ground was not properly stated, my lord.
Then what can be done?
My lord, then the suit was, my lord, not allowed. The restoration application was not allowed. In the next circumstances, he filed the appeal also, my lord. And he submitted the prescriptions, my lord, but it was not annexed with the appeal, my lord. So the appeal court held that the order in the restoration application was affirmed, my lord. So, my lord, the only thing is that he was ill, my lord.
Call the next matter.
Item number 291.
254. After the respond number 2 and 3.
What is 254?
Matter just
254, this matter.
yeah, previous one.
Yes.
And for the respond number 2 and 3.
Yes. You have got copy.
I got copy. They have subbed me advance copy.
Yes, they have subbed you in advance. Yes, what do you say?
Monthly listed.
Restoration application, why are you opposing, Mr. Ghosh?
এটা কিন্তু monthly listed to 254.
Monthly list or supplementary list?
Oh, supplementary list.
Yeah. This happens when you have so many matters, it happens. Yes, yes.
My lord, 291, my lord. Defendant in a suit for declaration, my
What is the impugned order?
impugned order, my lord, misappeal, my lord, dismissed.
Misappeal means injunction.
Injunction.
Both the courts have refused to pass.
My lord, refuse the pass.
What
My lord, I tell you,
Identity or temporary?
My lord, temporary. I tell you, lordship, I am the developer. I have constructed a building. The property belongs to some 5-6 members of a family. All of them have consented. Everybody have entered into an agreement. I am constructed at least 75% construction has been done. One of the elder brother.
This one, 291, this one. Yes, one number 2 and 3. I've been subbed with the advance copy.
Yes. Advance copy. Why have you served the copy?
Probably they will be supporting me because, my lord, I tell you,
They will be supporting you.
my lord, candidly, I tell your lordship, 6 owners, 5 is with me. One of the owners, though he is the party to the development agreement, construction 75% done. He have not vacated his position. Therefore, I cannot complete the construction. He came up with an injunction application saying that I cannot transfer, I cannot. That is the crux of the matter.
Don't transfer because it will complicate this. So if that is the injunction, I am expediting the suit.
My lord, and also, my lord, we have already given proposal to the plaintiff to exercise this option.
That he can do if you transfer.
No, I'm not transferring.
So I'm
transferring.
I'm expediting the suit.
But construction cannot be done. He is not.
You said you have been restrained only from transferring.
Your lordship kindly sees the order.
Where is the order of the trial court?
First,
not to alienate any construction, any new construction over the SVP property.
Page.
But inner page. After you will also give it after
just first at the instance.
But after page number.
By
not to alienate.
Yes.
By grab up this order, my lord, I am restrained from making any construction.
No. Where is that restraint order? There is no restraint order, only not to transfer, alienate. Please show me where is the restraint order with regard to the construction. What is the stage of the suit?
My lord, written statement filed. Issues were not framed till date. Injunction was going on.
Now injunction has been finished.
Now injunction has been finished. I have spent about 5 crores, 75% of the construction. My lord, let him come. But we are.
There is no injunction against construction, sir. Only
by virtue of this order. By virtue of this order, I am not in a position to raise further construction because he is in occupation of a certain portion. He is not vacating.
That is a different thing altogether.
He is not vacating.
That is a different thing altogether. But this order only restrains you from alienating.
And even
has to be done because if the third parties come, transfer alienation will be a problem.
Construction. I am making construction in pursuant to a sanctioned building plan.
Maybe, but you do not have an authority to construct when it's a undivided property.
No,
when
he was. Just a minute. He was there. It is not a case that he is not a party to the development agreement.
He has not signed.
Yes, he have signed registered a development agreement.
Then why is backing out?
That is the whole difficulty.
So the agreement was 40% for the owners, 60% for the developers. Now the developer selling out the prime locations of the property without giving me the.
That is why only.
I have also filed a suit that is annexed against the developer.
I tell you,
I have filed a suit.
All right, you serve.
I already filed my Bhagalatna minority.
একটা লাইন লিখে দেবেন, there is no scope to pass any.
For the petitioner, my lord. Petitioner is the defendant in a suit for eviction, my lord. Now, the trial court has suo motu appointed an inspection commissioner under Order 26 Rule 9, my lord. The commissioner has filed its report. Thereafter, my lord, before the commencement of the evidence, my lord, the commissioner had passed away. Now, if my lord kindly comes to the impugned order for once.
Yes, what happened?
My lord, the plaintiffs have filed an application, thereby praying to mark the commissioner's report as exhibit.
It's already an evidence in the suit, part of the record.
My lord, who has tendered it, my lord? Nobody has tendered it, my lord.
Sir, where is the law to tender?
No, my lord,
And for
the report,
where is the law? Order 26 Rule 10(2), automatically it will be an evidence in the suit and form part of the record.
yes, my lord, I agree. But the commissioner, but I cannot examine the commissioner, my lord.
Where is you paid for examining the cross-examining the
No, my
commissioner?
lord, before that, the commissioner has passed away.
Before the commissioner passed away. Yes, so the report cannot be, it automatically forms part of the record, sir.
But without the examination of the commissioner, my lord, I have raised objection through orally. I have raised objection.
That will be considered. The objections, veracity of the report will be considered.
My lord, if my lord kindly comes to the impugned order for once. My lord has got it. My lord, if my lord kindly comes to the impugned order for once.
Yes.
The third paragraph. Now the record is taken up for further hearing of the petition dated 27th of June 2022. That is the petition filed by the plaintiffs for marking the commissioner's report as exhibit, my lord.
Your submission was that it cannot be marked as an exhibit without cross-examination.
Not only that, my lord, there are certain defects, though I have not.
Yes, sir. So that is your, you only have a right to cross-examine.
Yes,
Nothing more than that. So it automatically, this application under Article 227 of the Constitution
Lordship, I am for the petitioner. Lordship, the tenant is the petitioner before your Lordship. Lordship, by the order impugned, Lordship, the order whereby my defense was struck off was revived, and also, Lordship.
Revived?
Yes. And Lordship also, an order, Lordship, where my 151 application was rejected, that was also revived. What happened, Lordship? Initially, I filed 7172 application. 72 application was disposed of in my absence, directing me defaulter for a period of 118 months.
In your absence, meaning thereby you did not appear on that date.
On that day, yes.
It is obliged to dispose of one way or the other. There is also a decision.
Yes,
It can.
yes. So, Lordship, what we did, we said that we have paid all, Lordship, there is no area. So, Lordship, we filed a review application. That was rejected. We filed a misappeal. That was rejected.
Misappeal?
Yes.
What?
Misappeal was not maintainable.
Yes.
Challenging that we came up before this honorable, that was rejected. An honorable court, that was rejected.
You have challenged that parent order.
No.
Miscellaneous appeal.
Yes. Now, Lordship, we filed a 151. In the meantime, the
151 for?
recalling of that order, Lordship, of 7-2 order, whereby, Lordship,
How can it be done? Earlier you have also filed that application for.
Lordship, what happened? In the meantime, they filed 7-3 application. Now, Lordship, 7-3 application was allowed. Challenging that, I came up before this honorable court, and my 151, Lordship, that was also rejected. Now, both these challenging that, I came up before this honorable court, both these applications were heard out together, and these orders were set aside. Directing, Lordship will kindly come to that order. That starts at page 41. And Lordship, the operating portion, Lordship, at page 46.
So what happened after this?
Yes, Lordship, what happened?
It
Lordship,
was directed that those orders were set aside.
yes.
And rehearing of the
51 application.
Yes.
And Lordship, it was held that if the learned trial court finds that the deposit of rent has been correctly made by the defendant petitioner of the said 118 month, he will be accordingly disposed of 7-2 application afresh and
Yes.
will proceed with the suit. But if it is found that there is any outstanding amount in connection with payment of arrear of rent for the said period which the petitioner has not deposited in accordance with law, then the order impugned in both the cases that is dated such and such will revive. Lordship, at page 46.
Then what can be done after this?
Lordship. Now, Lordship, what happens? I go back, Lordship. It is
Has been found
only
that
one.
18 was not made.
No, only one, Lordship. That too.
1 month.
1 month, Lordship, I could not show, but that amount, Lordship, I deposited before the court.
You have not shown. You have not shown.
No,
And,
but Lordship, that was deposited before the court. That was the first month, Lordship, which I deposited after appearing in the suit, after filing 7-1. But I did not have the challan, Lordship.
Then how can?
But Lordship,
And this order has taken. So what can be done? My hands are also tied. I am bound by this. I cannot go.
Lordship, the court's record may be called for because Lordship.
What can I do? One month outstanding, you are bound.
If Lordship, I deposited that, Lordship, records will be there with the court.
So what did the trial court say?
That I could not show. Lordship will kindly come to order dated 30th September 2024. Lordship, in the middle.
30th of September 2024.
Yes, Lordship. This court, Lordship, in the middle, this court is duty bound to abide by the direction of the Honorable Court and only to look whether the defendant has correctly deposited for all the 118 months. The defendant has stated in his written argument that the rent challan showing payment of rent for the month May 2005 to December 2006 and civil challan deposit showing payment of month of July 2009 are not available. But he had collected information slip showing deposit of rent of
Which page? Information slip?
Page, the first page of the impugned order. In the middle, Lordship.
Yes. Which portion? That information slip?
Lordship,
The defendant has stated in the written argument that
yes,
rent controller
rent control challan.
and the civil deposit challans were not available, but he has collected information slip showing deposit of
Rent.
May and December.
Yes.
So these are the 2 months.
Yes, 3 months were not available. I could
The
not.
defendant
produce-
also filed information slip issued by the additional elector showing the deposit. No, this you deposited before the rent controller.
These are Lordship pre-deposits, pre-suit deposits. And Lordship, this July 2009, it was Lordship a civil challan which I deposited in the court. And Lordship, so my submission there was that I have Lordship paid in
Question
excess.
of depositing rent for July does not arise during the period of 1999 as the suit has been instituted in the year 2010. So this you have deposited where? July 2009?
Lordship, before the court.
No, suit has been filed in 2010.
No, in 2007, Lordship. That is
The
wrong.
court records that it has been.
Recording, Lordship. Lordship will kindly see, come to page, my 7.1 application, Lordship. This is suit, ejectment suit number 10 of 2007, Lordship. Page 13G. Suit of 2007. Here, Lordship, I wanted to say that we paid, Lordship, some excess. So, Lordship, that can be adjusted. The learned trial.
Excess you could not also prove.
No, here, Lordship, I can prove.
No, you could not prove before the trial court.
No.
The
Lordship,
tenant cannot get away with the obligation imposed on the ground that some additional amount has been deposited earlier. Defaulted month. The law imposes an obligation on the tenant.
Lordship will kindly see in my 7.2 parent 7.2 order.
No, this civil deposit challan,
Lordship.
this is, you have obtained the,
Information slip.
where is that information slip? No, information slip is with regard to rent controller.
Yes.
Not with regard to July 2009.
No, July, I could not show anything.
Then?
That is what, Lordship, I am saying. At least, Lordship, if Lordship, we can call them for evidence.
You
also.
personally check. Have you personally checked up the records?
Because
Or
Lordship,
did your counterpart check up the records?
thing is there. No, what
Then-
happened? It was paid because Lordship kindly sees
So
that was the first month when Lordship I appeared.
I appreciate that, but if you cannot produce the documents, how can it be said?
Must
And
be
the
with the court's record.
damage has been created here.
I know.
If there is an outstanding, that order will revive. I cannot touch that order also. So unless you can show, if there is no document, records will not be there. If that is not on record, you cannot show July
At least, Lordship,
2000.
we can call the official Lordship. We can Lordship take evidence on that and Lordship prove it. Because for 1 month, Lordship kindly sees.
Who will prove? How can you prove that?
Lordship, that there will be Lordship document with the court because it was deposited in the court, Lordship.
That is why I'm asking you, what document do you have? Have you taken instructions? You don't have any document.
We don't have, but Lordship,
So-
if we have deposited Lordship, the court will also have Lordship some document.
Must be having the particulars when you have deposited. Who will search that?
Let us Lordship
God-
take a chance because for 1 month, Lordship, everything is reviving. We have given everything, Lordship. And Lordship, for some months, Lordship, double payment was made. Because Lordship, in the 7.2 order, Lordship, it was recorded that we produced rent receipts. But for the
Be
same
done.
period, Lordship, we also, Lordship, deposited before the rent controller. So, Lordship, double payment was.
But I'm bound by this order of the coordinate bench.
Lordship.
So that is the troubling me.
But only one thing, Lordship, if on evidence, Lordship, I can prove, Lordship. Give me
Prove
one.
that they are, prove that they are not here.
Lordship, one chance to, Lordship, adduce evidence on that.
Yes, do that there.
But if your Lordship doesn't set aside this order, Lordship, it will become.
On what ground I will set aside that order? Merely on the basis that you will be proving you don't have anything prima facie to show.
Because Lordship, from July 2009, Lordship, we started depositing in the court.
Why the suit was filed in 2007? Why from July 2009? It has to be prior to that, when the summons was served.
Yes, Lordship kindly sees, we appeared, Lordship, on 23rd of June 2009 by filing
Why this?
Vakatnama.
It took 2 years. You have avoided service of summons for 2 years.
That I don't know, Lordship. I do not have any Lordship instruction. I do not know. But Lordship, in my 7-2 application, this is my specific averment.
Chakravarti, once it is remanded, the court has the duty. If it is in form together with the admitted amount, the court is under an obligation to decide.
Yes,
But the trouble is that it has been said, if you fail to prove, that will get revived.
Let me, Lordship, a chance be given to me to properly prove it. One chance, Lordship.
What document do you have? You cannot prove. How you will prove?
Because first, Lordship, there were 3 months default. 2, Lordship, I have, Lordship, proved.
That is from the, you have produced some documents. Here you don't have anything.
But after getting chance, but regarding one, Lordship, I require at least one chance, Lordship. Lordship, 7-1 and 7-2 was disposed of together. Lordship, that
So
too.
7-1, there was no order allowing you to deposit at your own risk. There was no order of that.
That is in 2010. Lordship, this is a combined order. Lordship, kindly sees.
All right. The part to check the records. Yes, next. Order 464.
Respondent is the petitioner before your lordship.
Respondent
is the petitioner before your lordship.
Respondent in the title appeal.
Yes, my lord.
Yes, what do you want?
The
Occupation charges.
No, my lord. The appellant, for the appellant opposite party filed an application for eviction on the ground of reasonable requirement, default, and nuisance, my lord. He failed to prove his case. Thereafter, he prepared an appeal. In this appeal, my lord, he filed an application under Order 6, Rule 17
for amendment.
For amendment of the plaint, my lord.
Allowed.
It was allowed, and on the ground, reasonable requirement. My lord, the reasonable requirement ground was not pressed in the title suit.
But not pressed.
Was not pressed in the title.
Show me that.
It is page 31, my lord, of my application.
31 is the decision.
30
argument during the argument, the issue of reasonable requirement before the
court to decide the same in the presence of the The first line, the plaintiff during the
Yes,
argument
yes.
not press the issue.
And show me the amendment application.
It is in page 47, my lord. Page 47. 47 of my application, my lord.
What is the reasons on which this was allowed?
Nothing, my lord, no reason stated. And the just amendment was allowed. No opportunity was given to the petitioner to file amendment written statement.
There is substance in the argument of the learned advocate.
Is also started in the trial court also regarding the
evidence. So appeal has been allowed.
Yes, my lord. The order 6 rule 17 has been allowed and amendment plaint filed in the trial court and trial court started evidence on this.
Appeal has been disposed of.
And no, appeal are not disposed of. The application has been disposed of and thereafter the trial court proceeded with the
record the additional evidence. There was an application for additional evidence.
Yes, my lord. Order 47 rule 21 also allowed.
Order 41 rule 27. How it could be allowed prior to the in isolation with the hearing of the appeal?
I don't know.
তাহলে কি বললাম, serve a copy of this application by register speed post with acknowledgement due and file an application.
One.
Yes.
The petition.
What else one?
Petitioner before your lawsuit is the defendant.
Can you wait till tomorrow?
Yes.
Yes. কোটা ফরডাস কোনটা?
Item number 4 with 5 for order.
Yes. Why it has been fixed for what?
My lord, we can recollect, my lord, that 7-2 matters which, my lord, my friend has argued on the last day, my lord, the allowing of 7-2 application of the petitioner, my lord.
Yes.
I was arguing. this point.
What point?
7 application has been, which I have also filed an application. I am the tenant, my lord, but the landed court.
Oh, admitted rent. Where is Mr. Rai?
So he's there.
He is busy elsewhere. পাঁচ ওভার করে রাখুন ওই একটা সাপ্লিমেন্টারিতে একটা ফিক্সড
Item number 3110, daily list.
So Banerjee, which matter is yours?
878.
One matter has been urgent, that is why. This is the daily list I was proceeding, but from 3 p.m. I've started combined list. She has an urgency because something is likely to happen day after tomorrow. Yes.
Lordship, we came up for setting aside of an order directing ex parte proceeding of max suit number 766 in Barrackpur.
Suit has been directed to proceed ex parte.
Has been directed to proceed ex parte.
Yes.
Lordship, kindly comes to page number 62, annexure E. This is a settlement that was entered into by both the parties in PO 397. That is another item tagged with this one where.
What is 837 of 2021, CO?
397.
837. CO 837 of 2021.
837.
That is pending.
Lordship, 397, 837, we do not have any.
Please kindly come to the order dated 14th of November 2024.
That is a misprint, Lordship. That is a misprint.
That is?
That is a misprint. It is 397, not.
It should be 397.
397.
Not 837.
Not 837.
Oh, 397 has been assigned.
397 is tagged with this, 310 and 311.
So 397 of 2021 has been assigned before this court.
Lordship.
Both
the matters are tagged.
Assign হয়েছে
তিনশো দশ আর 311 একসাথে অ্যাসাইন না, এটা আগে কোড নাম্বার 5 ছিল, সেখান থেকে
অ্যাসাইন। Madam, this cannot be taken up. I cannot take up that matter. 2021 matter, I do not have determination.
Lordship, in this matter, the only reason the matters have been tagged together, Lordship, in this matter, 397.
397 could not have been added because you have said because 2021 I do not have any determination. How can I decide that?
We are not here for this matter. This matter is tagged only to show this terms of settlement, Lordship, which is there in this matter. The mediator was appointed for terms of settlement in 397.
Yes.
Lordship, kindly.
Now, what happened after that?
Lordship, terms of settlement. In there, we found that in the terms of settlement, it was decided that all matters, both max suit number 210, which was filed by the wife for restitution.
So this order, order is, it has been fixed for ex parte hearing.
Lordship, that matter was supposed to be, according to the terms of settlement, was supposed to be withdrawn. That.
Which matter?
39 item max suit number 766, which is we have come up against 766 in Barrackpur. That is there in this the terms of settlement is there in this matter. That is why Honorable Justice Raja
served upon the opposite party. Who is appearing for the opposite party?
Mr. Shivaji Kumar Das was appearing, but he is not briefed in the matter anymore. He has
You have
informed
not
us.
served the notice before mentioning.
Lordship, we have. We have.
When have you served?
Lordship, we have informed the over
When have you served?
over email, Lordship. Over email.
When? What is the date?
Lordship, we had informed them of on 5/2/25 when the copy was served.
You have mentioned on 18th of June.
No, Lordship, 18th of June. After that, we have served on 2nd July.
2nd of July. You have
2nd of
mentioned it, madam, on 18th of June. On that date, I have fixed that date. Yes, this is the mentioning slip.
Mentioning was done on 18th of July, Lordship.
Without
before,
giving
the
them
Lordship-
notice. Since not. Sorry.
For 552.
देखिए none appears for the petitioner. Wait.
Yes. My petition, my lord. In a suit for eviction, plaintiff is the petitioner before.
In a suit for
eviction, plaintiff is the petitioner, plaintiff landlord is the petitioner before lordship.
Yes. What is the order impugned?
7172 allowed. After
You are the landlord.
I am the landlord.
Why are you challenging?
Section 5 allowed.
Section 5 allowed.
Section 5 application separately filed and that has been allowed. Lordship kindly sees the impugned order.
What is the ground? Only default.
Default and reasonable requirement. But then
if
ex facie this is
there is substance in the argument of the learned advocate for the petitioner,
না না স্পেশাল বেঞ্চে না 6-0
Yes. Led by Mr. Ghosh. Yes, Mr. Ghosh. What is this?
A suit for declaration and injunction in respect of common passage. Well, admitted position, it is a common passage. This particular
What is the impugned order?
by impugned order, I sought for permission to place sunset on the windows. In view of the order of status quo, I sought permission, that has been refused. Against that, we have come.
Mr. Ghosh, modification of status quo order.
The other side was
effect
given.
of modification of the status quo order. So, is it not appellable? Even
Appeal
though you
was
have couched it as the
Appeal was preferred, appeal court Lord also refused. That's
Oh,
why.
appeal court.
Yes. Lord, similarly, Lord, they also applied for variation of the order to draw the pipeline underneath the
That has been allowed.
That has been allowed. Your Lordship kindly allow us to some notice upon them, let them come and your Lordship kindly decide whether it can be done. It is not just a quarrel between
By the order impugned, the prayer.
Petitioner, my lord, this is my application for expeditious disposal on the last occasion when this matter.
Of what?
Well, it arises from an order passed by the SESTAT.
Because hearing you are opposing.
My lord, it arises from an.
It is to be expedited in a.
My lord, on the last occasion when I had moved this application, a query had fell from my lord whether the matter is to be referred to the division bench because it is an order arising from a SESTAT appeal.
Oh, yes, yes.
Appellate authority's order.
Yes.
I have, with regard to my lord's view, my lord, I have gone through the order itself and also the judgments that are there. My lord, this is the judgment I believe on which my lord was referring to. I'm completely making my submissions as an officer of the court, bringing on record everything that I have come across, my lord.
So according to you, it's before the division bench.
My lord, according to me, the Supreme Court has directed it to come before the division bench, but there is a division bench order of our court and the provision itself, which indicates that it should be before a single judge. My lord, Chapter 2, if I may indicate.
My lord, I am for the, my lord, opposite parties that this order is applicable order. Your lordship knows 35G of the Central Excise Act, my lord. The order passed by the SESTAT.
My impression was that it has to be before the division bench.
My lord, my lord, my lord.
This is not a final adjudication. This is from an application for expeditious disposal, which was rejected from March 2024. My lord, no steps have been taken. And my lord, if I may also indicate.
No. This is a different thing altogether. Show me that statute under which this appeal has been filed. Statute says.
It is under the Customs Act. Central Excise and 35G.
35G. 35G is before the division bench.
My lord, this judgment also indicates that it will go before the division
Appeal
bench.
shall lie to the High
But
Court
my
from
lord,
every order in the appellate tribunal. For the purpose, where is the appellate tribunal rules? Act, appellate tribunal.
My lord, 35B is the provision for preparing appeal before the tribunal. And against that order, my lord, 35G is for before the Honorable Division Bench of the, my lord, High Court.
but my lord, there is one division order.
This is a tribunal constituted.
Under 129 of the Customs Act.
No.
My lord, this
Yes.
decision bench order, my lord, if I may please. My lord will kindly consider Justice Aniruddha Bose and Arindam Sinha's order, my lord. This is an order passed wherein, my lord, it is indicated at paragraph 1 that this is an appeal which is arising from appeal. Rather, the SESTAT has been constituted under section 129 of the Customs Act and is not a tribunal under Article 323B of the Constitution of India. Thus, we do not have determination to directly entertain these writ petitions while sitting in the division bench. And thereafter, my lord, on the basis of the judgment,
Then all the judgments under 35G of the division bench will be a nullity.
This is the observation, my lord. And thereafter, it was directed to appear before the single bench under Article 227. But this is what I've come across.
This is the tribunal constituted under which provision?
Well, it should be under 129 of the Customs Act.
Customs, this is the central excise matter.
My lord, may I place, my lord,
Always
the appellate tribunal.
Consider this. Because these matters are being heard by I was a part of that division bench. That is why it struck me.
My lord,
my lord, section 35G itself, is statute itself is clear, my lord. Whatever may be there, my lord, my landed friend is adjusting to your lordship, my lord. Section 35G.
Mr. Bhattacharya, statute does not say that it's a division bench or the single bench. It says if the High Court is satisfied that a case involves a substantial question of law.
My lord, may I do the leave of my senior?
Substantial question of law, my lord. Only division bench can be from the heart, my lord. That's why the decisions are there. Decisions are there, my lord.
Monthly list দেখি
সেন্ট্রালাইজেশন বই নেই না
আমারটা না 67
একটাই বই ছিল আমার
All right, I'm making it not today. Let me check.
And my lord will only consider this is not a final adjudication.
Maybe final interim, same thing. Do you mean to suggest interim single bench, final division bench?
Not on that. I am saying that, my lord, since in case of a final adjudication, if I was coming up by way of the appealable, whether it is an appealable order or not, on that score, I am only submitting that it is not a final order. It is only in respect of the fact that it is not being heard.
No, your submission is that you are only paying expeditious hearing.
Yes, my lord.
So if the court single bench do not have determination, cannot pass any order. That's my personal view.
Absolutely, my lord.
Even if it is expeditious hearing or not.
Absolutely, my lord. I agree with that. I was only contending what my learned friend said. It is an appealable order. It is not an appealable order because it's not a final adjudication.
Not that. Whether it will be before this.
My lord.
Yes, call the next matter. Next week next week today. Yes.
Lord, may I get back the appellate side?
Yes, yes. Take back.
Much obliged, my lord.
Yes.
My lord. Item number 822.
Pass over next.
Item number 878.
This is my opposite party. Led by Mr. Saptangshu Basu, my lord. He has the arbitration 4:30. He has left, my lord. Make it not today.
What is this matter?
Let the challenge to award passed by the MSME West Bengal Facilitation Council.
Award pass?
Yes.
This is 34 then.
Yes.
No, my lord.
There are some cases which says possible in a 2 to 6 I have seen some of the cases. But ideally you have to go to section 34.
Yes.
There's also provision under section 19 and I'm bringing it to my learned friend's attention also where 75% has to be deposited before any challenge can be proceeded with.
Yes.
Otherwise, it defeats the purpose. You do not go to a section.
Bypassing a statutory remedy,
Yes.
you are coming before 227.
These are rent. My learned friend's client, my lord, carries on, my lord, with a club and bar, my lord, in Rajarhat. My lord, for ground floor, first floor. My lord, the rent amount 2 crore 2 lakhs, my lord, is outstanding. With, my lord, interest.
Or Mr. Vasu will show some authority, lordship, of the Supreme Court, my lords. But if it's they pass in the beyond the jurisdictions by the authority, my lords, that can be challenged on the 227 lordships. But you kindly make it to the not today, my lords. My lords, initially that's the opposite party.
So NSME that Facilitation Council that has passed an order.
Award.
Ex-party.
Passed an award.
Award.
So against that, I think section 34 is the remedy.
My lord,
34, my lord, any award has to go to 34.
That is there, my lord. But still, if it is the award passed completely beyond his jurisdiction, my lord, there's to file to proceed. That's
I think one of the grounds under section 34 is that.
Yes.
One of the grounds is 34. 34 scope is very limited.
Lordship, there is
one of the grounds is that
there
it
is the authority even without going to the 34. I can challenge the 37 if the award is passed without the jurisdiction.
But what do you say to the mandatory pre-deposit? As in these, yes, court can also impose that condition.
My lord, if that is there, then definitely my client has to deposit the lordship. If lordship kindly make it not today, tomorrow late. Lordship kindly hear to Mr. Vasu. Then if lordship develop.
One request, my lord, from 2 to 3, my lord, I have a matter fixed, my lord, for another court. Lord, I don't.
If you have any difficulty, please remind me.
Well, just my lord, if my lord, it gets called on after 3, my lord, no difficulty, but before 3, my lord, I might.
To ask your juniors to. Yes, next call the next matter.
Great.
Yes.
Great.
Number 1148.
Lordship, this is my application for expeditious disposal, Lordship. I am appearing online.
Yes. Expeditious disposal of what?
Expeditious disposal of this title suit number 44 of 2021 pending before 7 Civil Judge Senior Division Alipur, Lordship. My suit is for recovery of possession and decree for mean profit, Lordship. Lordship, before I start submitting, I should indicate this, Lordship, that on last occasion the suit was taken up for hearing on 1st of July, and on that, Lordship, my order 22 rule 10 application got allowed on 1st of July. Allowed, Lordship.
Yes.
And then, Lordship, so therefore my prayer number 2 is not there anymore. But I have also prayed, Lordship, for expeditious disposal of the entire suit. Now, if I may take your Lordship through the orders.
This application under Article 227 of the Constitution. That the instance of the is that the instance of the plaintiff paying for a direction upon the learned civil judge senior division 7th court at Alipur to dispose of title suit number 44 of 2021 expeditiously. First of in view of the order, the learned advocate appearing for the petitioner submits that in the meantime, the application under order 22 rule 10 of the Code of Civil Procedure stood allowed. First up, in view of the order sought and proposed to be passed, there is no necessity to direct issuance of any notice upon the opposite party. First of all, however, the learned advocate appearing for the petitioner shall be obliged to forward a copy of this application along with this order upon the opposite party or upon the learned advocates representing the opposite party before the learned trial judge. First up, in the light of the submissions made, the learned advocate appearing for the petitioner submits that the hearing of the suit may be expedited. In the light of the submissions made by the learned advocate for the petitioner, CO number such and such stands disposed of by requesting the learned civil judge, senior division 7th court at Alipur to make an endeavor to see that the title suit number 44 of 2021 is disposed of as expeditiously as possible without granting any unnecessary adjournments to either of the parties, provided the suit is otherwise ready for hearing. Yes,
I'm grateful, Lordship.
Number 1188.
Pass over next.
Item number 1203.
I'm for the opposite party. My lord, this is upon our instance, it has come up. We gave notice on the day of hearing. My lord, it is there annexed with the mentioning notice. On 7th July also, we have given a notice. DRT order challenged, my lord, 27 crores of a nationalized bank is stuck due to an order. My lord,
Right, not today. Yes, next.
My lord, let it kindly hold its position, my lord. There is some urgency.
Yes, next.
1298.
No. 1298. Lordship, I am appearing for the petitioner.
Yes.
Lordship, expeditious disposal of the suit. Suit for permanent injunction. I, being the defendants, appeared and filed written statement with counterclaim for recovery of khas possession. Lordship, matter is pending since 2020. Lordship, suit is thereafter they have filed various frivolous application. One is for repairing the suit premises that was allowed.
This application under Article 227 of the Constitution.
Time frame, if possible.
Yes, next.
Item number 1320.
Pass over next.
Item number 1330.
Lord, I am appearing on the behalf of the petitioner, my lord, that it is the application for the expeditious trial, my lord.
What is the stage of the suit?
It is the stage of the suit is the appearance of the defendant, my lord.
Have they appeared?
The appearance stage. It is
Have they appeared or not appeared?
appeared, my lord. And it is the surfacey matter, my lord.
It is a
Surfacey matter, my lord.
this application under Article 227. Yes. Pass over next.
Number 1416.
Lordship, I am for the petitioner wife. I shot for amendment in 5 places. Out of that, one was just for spelling mistake that was granted, but other 4 was not granted. Now, Lordship, the thing is that out of that 4, I need only 2. That other 2 will not hurt me much more, Lordship, but other 2. And that
That is an amendment application.
that is Lordship Annexure C at page 30, Lordship. Now, Lordship, principally in case of
Your application for amendment.
Lordship, page 30, Annexure C, Lordship. And Lordship, may be pleased to come at page 5 of my petition at paragraph 12. I have summed up my paragraph 12, page 5. Only, Lordship, in case of page 5, paragraph 12, Lordship, I have in case of
Civil division application.
Lordship, amendment application I have made, that was
Amendment application
was
page.
Lordship, Annexure C, page 30, Lordship.
30.
Yes, Lordship.
Yes. By the order impugned, the
Number 1534.
Mr. Ashok Kumar Jena is appearing for the petition. My lord, due to some personal inconveniences, he is not in court. If my lord keeps the matter tomorrow. It is that matter, my lord, where the temporary injunction was rejected in was stayed in miss appeal. Till disposal of the miss appeal.
have you served upon the other
Yes, yes,
side?
yes, my lord, I have served, my lord. This is the affidavit of service, my lord.
No. Did you give them notice prior to mentioning upgradation?
Lord, I'll serve them and my lord,
Since
A poor advocate running from pillar to post to earn livelihood.
84
of
the monthly list.
the monthly list, which is fixed, my lord.
Yes, 84 of the monthly list.
See on 4212 of 2024.
Yes.
Suit filed under on the ground of 2G. Whether I am liable to deposit 12 months rent for the purpose of asset.
Suit for eviction of a tenant.
Tenant, not tenant, my lord. 2G. So it is trespasser. It is a trespasser. So I can value the suit according to my own valuation so far the trespasser is concerned. Whether I am liable to pay court fee on the basis of the assessment 12 months rent or not. This is the only thing we got to consider. So it is my suit, but the amount was directed.
The Court Fees Act.
Hey, rakho.
715.
715.
The Court Fees Act.
Trespass suit for trespass consider.
Court Fees Act. Where is the Court Fees Act?
সকালবেলা পাঁচটি মিথ্যা On consideration of the plaintiff in this court, the suit relates to eviction of a tenant. Pause there for a moment and one can consider the plaintiff itself.
Where is the plane?
Yes, it starts on page 9, my lord. Can you turn to paragraph 9, 10.
Paragraph 9.
9 and 10. That the defendant is the statutory trespass in respect of the property which they want.
When the original defendant died.
The 2019. 9th March 2019. So after promulgation of 97 Act.
Yes, 2019.
Yes,
and
this suit was filed
on
23.
So not 5 years have not expired, Mr. Rai. How could you file this suit under 2G?
There is no, before that, man. Original tenant man.
You said 2019 and 2023. I'm going by your dates.
Yes, the original one, Uday Shankar Ghosh, husband of the plaintiff number 1, was the original inducted tenant, was died on 22nd March 2004. After that, the wife.
2004.
4. Paragraph 3. Your lordship find in paragraph 3.
So thereafter the wife.
Wife and others. Wife died, my lord. শান্তনা ঘোষ, এই শান্তনা ঘোষ কে মারা গেল? শান্তনা ঘোষ কে মারা গেল? শান্তনা ঘোষ died on 9 July 2020. হ্যাঁ।
No, Mr. Rai, if it is 715, this is to the value of the subject matter.
Yes.
It's a suit under 715V or 5.
V.
So it has to be on the basis of the valuation of the subject matter. It cannot be own valuation.
Valuation of the subject matter.
Valuation of the property.
Yes, but here, my lord, what he has said, my lord, if you logically consider the trial court has said.
What the trial court has. Yes.
Payable according to 600 such and such, payable according to English calendar month, and as per the suit valuation, proper suit valuation of the suit property will be rupees such and such into 12. It is the suit valuation of regular eviction of regular tenant. I could understand that it was asserted and the valuation has been directed to be paid. Whether I am bound to pay the valuation in terms of the eviction of a tenant or not, and whether
you have to value at a market price.
Market
price
if,
will be more than 30,000.
If it is market price, eviction of a trespasser.
Yes. 715.
715. If you are possession, it is not a position taken. Can you consider
trespasser under what? Under accepting 715, there is no other provision for this.
This trespasser, if you logically consider this, if the trespasser in that sense, then my lord, it is not a recovery position under the Specific Act. But can you consider it is not a recovery position? What is, my lord? The trespasser which is embodied in the Court Fees Act, it is regarding their lost position, and subsequently it is the declaration or recovery of position or khas position. But in that sense, my lord, the advance court fee required to be paid on the market value. But where is the statute? Under the statute, it has said.
You will bring your suit under which provision of suit?
Regular eviction.
Yes. No, under the Court Fees Act, under which provision? You have to pay court fees according to this, value your suit according to this. Show me. Under which provision? You cannot say in 714, 711, 712, nothing.
1B, subject to question if you lost. 1B.
Where is 71B? It's 715.
Yes. My lord, if you logically consider the court fees in respect of landlord tenant. Landlord and tenant. The following suits being landlord and tenant for delivery of tenant by the counter.
It's not a suit of landlord tenant. When you are saying trespasser, it cannot be a suit between landlord and tenant.
If you logically consider,
you do not fall within this.
7.
You cannot bring your suit within this, Mr. Rai. So you have to fall within 715 market value.
The position that was interested.
The issue that arises for consideration is whether
My lord, if you
a
lost
suit instruction in that
yes,
matter.
I had talked, Mr. Pankaj, huh?
Which item?
Oh, yes. 2500.
I requested Mr. Rai to take.
That is the item number. ওইটা বললে হবে না। 250? 250.
I requested them to take.
Yes, Mr. Rai, what is their instruction?
Considering the age of the clients.
Well, he said that he talked with the.
Kindly keep it after a week, my lord, or any day as your lordship wants. Let him talk if there is any practical solution. If not, your lordship, we will fight for it.
I'm appointing you as the mediator. You mediate.
I will never be able to make understand anybody. Let him have his talk and let him say. Both are acceptable to me.
250. 250 ki monthly na supply?
Convince anybody.
Monthly or supplementary list?
Daily list. Daily list 250 it was.
পার্থপ্রতিমরা কিছু মনে নেই কোনায় দাঁড় করিয়ে দিল আছে
আজকের 250 ছিল
আজকে ডেইলি লিস্টে 250
এক সপ্তাহ পরে
যা জর্ষা জয় বলবে
as your lordship
তাহলে তুই কথা বলে নিস ইয়ে করে
না বলে যেটা হবে বলে কোনো প্রবলেম নেই কেন আমি বল they will take info share with me.
Yes, and 3 and 4.
4 and 5.
4 and 5.
Yes, 4 and 5 what?
The 7-2, my lord was pleased to fix.
Yes.
Whether last paid rent.
Where are the judgments? Give me the judgments. You have brought both for against.
I have brought last paid rent. What is there is something that 17.1. It is under 17.1 when it is not controlled under section 21 at that point of time. Rent control registration. The rent control any process spending it is not guided by that proceedings. That was there, my lord. May I hand over to your lordship, my lord?
I indicate your lordship. Some points are there, my lord, to assist your lordship on this matter. My lord, if your lordship can keep it.
Give me the decision.
Yes. One is, my lord, 1990, volume 2, Supreme Court cases, page 651, where it was said, my lord, একটুখানি না বললে ঠিক আছে আমি দিয়ে দিচ্ছি 5 o'clock my lord. I'm handing over to your lordship. If your lordship fixes it, so I can.
He wants to make some arguments.
Yes, that is why.
Please give him the decision so that he can also consider that.
And 64 CWN page 880.
Yes, that is the CWN judgment where it is fair rent and the contract.
That is what precisely.
60. I was thinking 6 CWN.
For the Mukherjee.
That is 64 or 68.
That is 68.
68. Then I'm right.
It's 64. 64.
I thought 68.
64. And this is, my lord.
Is there any decision in 68 CWN? Please check up.
This is, my lord. 84, 80 CWN, 87 CWN. Remington Rand.
Yes, Remington Rand. That is also on contractual and
These are the judgment, my lord. I have handed to get an
Give
immediate
him the references, Mr.
reference. 64, actor 64 CWN, actor 68 CWN.
Give the page numbers also.
7 CWN 922. These are the more or less, my lord. These are the, and the Supreme Court is very clear. I get a Supreme Court
What
judgment.
did the Supreme
Last
Court?
paid rate. What is the rate and what will be the
What is the last paid rent according to the Supreme Court?
tendered?
Tender.
Tender to the landlord. Last contractual rate paid.
Yes.
They have the last contractual rent paid according to my landlord.
Here, according to you, according to his
1200.
own admission, is 1200.
Last contractual rent paid.
Yes, rent paid. That is the statute also says that
It is
rate at
not
which rent
negotiated
was
subsequently payment of rent at the rent controller with 500 rupees, which amounts to, that will be the last paid rent or last paid rent to the landlord. What will be the terms? But last paid rent, the Supreme Court subject
because deposit of before the
contractual rent.
before the rent controller is nothing.
Guided, because there's a reasoning given that if you did not get any receipt to the rent tender, then you have to apply under the rent control registration
36,
for
35 or 36. So you have to approach and say that this has been done. The landlord is not issuing the rent receipt.
8 hours.
So they are
8 hours.
there is a procedure for that.
So you cannot unilaterally cannot deduct and deposit the same. This is subject matter of my submission, my lord, if my lord if it wants.
Let me on tomorrow, my lord. I'll place my things, some things, my lord.
When? Tomorrow?
Tomorrow, day after tomorrow, as your lordship pleases, my lord. As your lordship pleases, my lord.
কবে আছে কালকে? কালকে কি?
Position amount which is relief sought is valued in the plane subject to provision 6. Well, I've got it. 6.
$415, same.
Grateful.
1374 tomorrow, my lord. Passover 1374, my lord. Combined list.
What is there?
Passover.
What is that matter?
Judgment. Order to rule 6 has been rejected, my lord. It requires some consideration. Only Passover, my lord. Can you get
7, it has been passed over, I think.
my lord, it is Calcutta. We are apprehending some other things.